Well, hey there, everybody. Welcome back. Day 18 brought a distinctive shift in mood. It's the trial in the case of State versus Richard Allen. So, I'm going to be telling you guys about some of the things that were a little bit different today when we showed up to court. Uh, the line sitters are heroes. It's really all I can say. It was really pouring down rain when I got there this morning. It was really not a pleasant evening, I'm quite sure. For anybody who had to stay out in it last night, it is kind of continuing to do that again tonight. So I once again just remain incredibly grateful to the people who are making this sacrifice of their time and certainly of their comfort to go ahead and show up there and get the seats to make sure that we are able to get into court and continue reporting for you. So no trouble getting in this morning. Not anticipating any trouble getting in tomorrow. So let me put all your minds at ease about that. But yeah, things did get a little bit different around the lunchtime, and so I'll talk about that when we get to that point. By the way, if my voice is a little bit quieter today, I'm starting to sound like I have laryngitis or something. So it's just trying to protect it and not sound too horrible while we're doing this live stream. I did get lots of rest this weekend. Slept till 11:30 yesterday. It was glorious. I had kind of tentatively made some plans to go out hiking with folks over the weekend just to get a nice break, nice time away. Nope, didn't happen. Slept way too much. Went to bed early last night, slept some more. So I'm in very good shape. This is not like painful or anything, just I think an accumulation of wear and tear. The body, what's the saying? The spirit is strong, but the flesh is is weak. So that just happens sometimes. When we did get in this morning, one of the very first things that I noticed is that the media is beginning to occupy the seats that have historically been allocated to the defense. And what particularly stood out about this was that at least one person from the family's team, who's been there consistently throughout the trial, ended up not being able to stay in the courtroom because seats that had previously been allocated to the defense were now being taken up by the media. So I don't really know what the situation is there. The court order, as far as I recall, says that the defense and the family of Mr. Allen is to be allocated 10 seats of their own. They got 5 this morning. So not really sure what all that's about. Can't say I really thought that was very cool. There's been a whole front row on the far side of the courtroom that has been the press's row. They have both of the 2 front rows in the courtroom, and that row was nearly completely empty. It appears that the press would prefer to all sit on the defense side of the room. So I'm not like, it's not obviously that everybody on this side is defense or anything like that, just behind where the defense is seated. Because you have a better view of the screen from that side on the left-hand side of the courtroom, like from inside the courtroom, lookers left, for you skiers. No, I'm sorry, skiers left, lookers right. You would be often kind of behind the screen, and so you can't really get a good look of anything that's displayed. So I didn't really care for that. Made a note of it. Definitely paid attention to it. Those of you on the Mr. Rosie style watch, quite a tie today. He wore it with his navy blue suit and white shirt. This tie was wide pink and purple diagonal stripe, and there was a very thin turquoise detail stripe in between those stripes. Very striking tie. It's not the kind of thing that I would ordinarily think would work with navy blue, but it actually did. Thought it looked pretty good. I did also keep our sidebar count for today. We had quite a number of sidebars, but they were mostly short. So we had a total of 15 sidebars today, for a total of approximately 41 minutes of the court time that was spent there in conversation. Before we got started, we had the normal questioning of the jurors because they had had contact with their families. And again, everybody continues to attest that they have not checked the media, investigated, had any contact with anybody who's tried to talk to them about the case, and so forth. Ms. Diener also addressed the court before we got started. She was saying that she had previously asked for separation of witnesses with respect to Dr. Martin, but noted he was not present for Dr. Walla's testimony and that she was withdrawing that request. So, don't know if or that Dr. Martin was present today, but he would have been allowed to be at this point. Apparently, the state was no longer concerned about him being in the courtroom. And so our first witness for the day was Dr. Polly Westcott. She is a 49-year-old neuropsychologist from Carmel, Indiana. She has been in Indiana since she did her residency in 2004. She has a PhD in clinical psychology with specialties in forensic psychology and neuropsychology. She talked a little bit about what those meant. So, as we've heard before, with forensic psychology, we're talking about kind of the intersection between psychology and the law. She described it as addressing mental health or cognitive issues and helping courts to understand if a condition affects the person's ability to think things through, be competent to testify, and things of that nature. The neuropsychological specialty relates to the brain as being the control center over functions and emotions. And so the role of a neuropsychologist is to understand behaviors and how they tie into aspects of brain health. She was hired by the defense in May of 2023. She is paid $450 an hour for forensic work. In my experience, that's nothing extraordinary. That is pretty routine. It always depends on the market that you're in, but I was also in a relatively small community, and this type of rate would not have raised my eyebrows. She has worked for lawyers before. She has worked in criminal cases before. She addresses a variety of factors, including things like whether the person knew right from wrong, whether they have a mental health background where they can't participate in testifying or understand what's real and not real, and also with developing mitigating circumstances that are relevant for sentencing. She's also been an expert in civil court, and she has been asked to work for both sides. Most recently, she worked with the prosecution about a couple of months ago. She will be contacted by prosecutors to ask for review of records, to evaluate if somebody is faking their mental health, and to also just explain some mental health issues like, what schizophrenia is, what it looks like, things like that. She has been consulted about 72 times formally, and she has testified somewhere between 25 and 35 times. Dr. Walcott has extensive experience with Westcott. Dr. Westcott has extensive experience with prisoners. When she was in college, she worked at the Wabash Hospital and took inmates who were in crisis and stabilized them. She also worked at another prison where she did evaluating and testing to determine mental health conditions. She started her private practice in 2006, usually involving pretrial detainees, where she evaluates their condition and their ability to testify in court. So these would be competency evaluations, whether this person is in the condition where they can meaningfully assist with their defense. If they are not, then they are not allowed to be brought to trial. We only try competent people in the United States. She's also worked with the police in crisis intervention. She developed a program where she would educate police on different types of disorders and cognitive difficulties, train them in how to communicate and interact with people in crisis. For 12 years, she was a contracted psychologist for the Indiana State Police. This was something different than the crisis intervention. I believe this is the education component that she was referring to before. So her CV was admitted into evidence, and she has also published articles and things like that. So on a day-to-day basis, she has a clinical practice where she does the same kinds of things that most practicing psychologists do: therapy, assessments, and diagnosis of brain-based and mental disorders. She will often get questions from folks like medical doctors and sports coaches in her capacity as a neuropsychologist. And the assessment that she gives them is to help guide the treatment that those patients would then receive. Approximately 50% of her practice is forensic, and in those cases, she is hired by a judge or an attorney. Quickly touched on the difference between a psychologist and a psychiatrist. They are different educational programs. The psychiatrist goes to medical school and is primarily known for prescribing medications for mental health. The neuropsychologist is a bit of a hybrid. They take psychology in school, but they also take medical classes concerning the brain, and they have to complete a specific fellowship. Neuropsychology is more focused on assessment and treatment, as well as the use of objective tools to assess conditions. So as for Richard Allen, when she was first contacted by Mr. Rosie, they told her about, broadly about the situation and the decline that Mr. Allen had been undergoing. This recall is in May of 2023. So she had three objectives with her involvement in the case, her engagement. The first was to examine his mental health history and look at what was the history, what was the nature of any of it. Second, to do a neuropsychological evaluation at the time. And then three, to offer an opinion about the breadth and decline of his physical and emotional functions, and to look at the situations and factors that were at play in the confession activity. She reviewed a large number of paper records, including records of mental health history and treatment before the time that he was incarcerated. She reviewed the records of the suicide companions, the watchers, she called them, medical treatment records, video footage of his incarceration, listened to his phone calls. Ultimately, she says she was provided an enormous amount of information that is atypical for the evaluations that she normally does. Normally, they don't have video footage of behaviors. She had more than 20 hours to watch, as well as the notes from the observers who were documenting his behaviors. Normally, pretrial detainees don't have that level of scrutiny and observation. So kind of a little bit of reversal of fortune in some ways. That kind of constant surveillance that he was under ultimately gave the psychologist a lot more tools to be able to evaluate his condition. So she got everything, she says, from Westville. After Mr. Allen was transferred to Wabash, she stopped getting information about him around March or April of this year. So she met Mr. Allen, described that pretty typically she will request to meet with the individual that she's evaluating as well as their family. It was in August of 2023 when she went to do her evaluation at Westville. She described it as a 2-hour interview and then about 5 to 6 hours of testing. Typically, her evaluation would take somewhere between 1 to 2 days. In this case, they spilled it over to 2 days. She has a assistant. This assistant has a special name that sounded like it's a term of art, but I couldn't catch what it is because I'm not familiar with this practice. But it's a name for another person that basically does her testing for her. And the reason why they do that is in part to distance her from the test administration. And the other part is to make sure that the test is performed consistently over time. It's always being done by the same person in the same manner. And this evaluation did take place in the WCU, in the solitary confinement unit. Based on her evaluation, she generated a report. In that report, leading into it, she had also requested to speak with his family. So she met with Kathy several weeks after meeting Rick. She also asked for additional records after meeting them to follow up. She didn't have all of his medical records. There seemed to be some logs that were missing. And she also asked for photographs and handwriting samples. And based on all of this, she produced a 127-page report. Some of that is including a chronological summary of the records that she reviewed before and after his incarceration. So it's not all entirely just her process and opinions and thoughts. There is some kind of record keeping or sourcing of information that is included in there. Starting with Rick's life before incarceration. She reports that he's had an extensive mental health history from his time as a child. As a young child, he had intense anxiety about school and fears about going to school, and intense fears about something bad happening to his family. He has intense fear of people looking at him and thinking badly about him. In his adulthood, the anxiety became prominent, and so he started medication for it in his 20s. The depression followed later. She described it as a reaction to his anxiety. He has fear that he's failing his family, which is not true based on objective observations about how he performs in life. And that leads him to feel worthless, leads him to want to die and to want to hurt himself. From the time of his 20s, he was being seen for treatment and medication. He has a clear-cut histories of external stressors making him fall apart. Specifically, she described curling up in a ball and crying. Most of his adult anxieties consisted of either work-related anxieties, fear of failing at work or not performing well at work. She noted that in his history, he's had 3 long-term jobs where he's been loyal, he's been liked, and he's been promoted. But what happens is that would add stress. It would put him in situations where he had to tell people what to do. So he would get depressed in that environment. However, because the company liked him and supported him, they would keep him on. And so this happened. She reports 3 times over the course of his work history. His wife plays a key role in kind of putting him back together, keeping him together, making him feel good about himself, because he will cycle into fears about not taking care of his family, which is, again, not true. She was asked about the family history of mental illness. Family history can be a significant factor. So Ms. Diener objected at this point to ask, is all of this information coming from Richard Allen? She said, no, these are coming from the medical records that she reviewed, but they are all reports. It's not like she got medical records from Richard Allen's family. They were Richard Allen's reports about personal and family history, not their own records. So Ms. Diener objected on hearsay grounds to this, and that objection was sustained. I've got a BS note in my margin here because there is a hearsay exception typically, and this comes up later as well. There's typically a hearsay exception for experts who are testifying about the bases of their opinions. Experts can rely on hearsay or anything really that is not ordinarily admissible in court if that's the type of thing that experts in their area would typically rely on in order to generate an opinion. So yes, it's very common for medical professionals to rely on what people tell them. It's an important part of the process. But nevertheless, that was sustained, so we did not get information about Richard Allen's family history. Going back to his personal history, there was always a time when he was suffering from anxiety or depression. There would be times when his symptoms would improve, and those were typically when he would switch his medication or when his work situation would improve. She described one example where he was working away from home at some distance, and he deteriorated under those circumstances. Once they were able to be reunited, his situation improved. She asked about whether she had conducted a personality disorder assessment, and she identified that Rick suffered from dependent personality disorder. So she described this as that he really needs other people to feel whole. He feels alone. He feels very worthless. He relies extensively on Kathy and to a lesser extent his mother to get reinforcement that he is a good person. He would spend an abnormal amount of time with his spouse, would have a hard time making decisions alone or just generally functioning alone. Because of that, incarceration would have a huge impact on him because this personality disorder comes with a fear of abandonment. So he needs interaction and reinforcement from others. Without it, he would fall apart physically. This happened when work separated him from family as well. Through her report, she drew 6 main conclusions. I'll walk through what they all are bit by bit. The first conclusion she drew was that Mr. Allen has a long history of mental health issues. She described him as a fragile egg, as in, cracked, easily cracked. His father had abandoned him in early childhood. Ms. Diener again objects to this on hearsay grounds. And at this point, Mr. Rosie responds that conversations like this are a normal thing for experts in this field to rely on, and so the objection was overruled. Nevertheless, they really didn't go any further into this. Long history of mental health issues. He's fragile, and he has abandonment issues that are likely precipitated by his father abandoning him at a very young age. Second conclusion she was asked to draw was whether he was lying or exaggerating. She discussed the concept of malingering, where somebody is faking symptoms to try to avoid responsibility. This she described as a multifaceted evaluation. She would use testing tools that are supported by decades of research that tell us if there is either exaggeration or underreporting. And there are tools, those are tools that help them determine the accuracy of the report that they're getting because, of course, they want to be making their conclusions based on accurate information. Additionally, she's also looking for consistency in reporting. So she's looking for things in the videos and in the audios and how he is presenting and looking at whether his presentation is typical or not. A question raised about how can you make conclusions in August of 2023 about his condition during prior dates. And she said she has lots of records and videotapes and audios since the day that he was incarcerated that enable her to be able to make that evaluation. Her opinion is that he had some kind of psychosis. And so what she was looking at is to see is what he is displaying and saying and so forth, how his behaviors are manifesting. Are they consistent with psychosis? And that was how she was able to get a retroactive perspective on his condition. Her finding, number 3, finding from the tools was that she ruled out, oh, I'm sorry, that's not quite number 3 yet. Maybe it is. Yeah, she did say it was number 3. The finding from the tools was that she ruled out that he was either faking or exaggerating or putting forth insufficient effort into giving a response. These are all possible invalidation measures that can come through with some of these tests. They'll be looking at basically patterns of reporting, like how questions are answered in certain ways. And so like with insufficient effort, they have ways to tell if you're just kind of sort of randomly going through the page and just checking whatever without really paying attention to it. They can also see how you are answering questions to see if you are exaggerating your condition, or also underreporting it by looking at how your answers relate to answers of individuals who are typical for the types of disorders that are being presented. Based on those results, she found that he had significant slowing in his cognitive abilities. This simply means he was thinking slower. It took him longer to perform these types of cognitive processes, that his performance was in approximately the 5th to 6th percentile at this time. Next issue she was asked to address that she drew conclusions about was what she called the frontal lobe control of executive function. And so this is really addressing a person's ability to problem solve. In this case, she evaluated his skills as being in the 2 to 4 percentile. This issue also addresses perseveration. I had wondered if we were going to hear about this, and we did finally hear about this from Dr. Westcott. So perseveration is when, as she describes it, people get stuck on concepts and they can't be pulled off of them. They can't control their thinking process to get away from the things that are going through their mind. She said he has a hard time going from like transitioning away from the topic that he's stuck on to the next one, and that in colloquial terms, you might call it overthinking. Before he was incarcerated, his perseverations focused on constant fear of failing, of not meeting standards for performance, a fear of not financially supporting his family, even when he is objectively successful in doing that. They own a home. He has kept his job, and succeeded in his job, advanced in his job, and so forth. But he will still nevertheless suffer from these fears. Additionally, he would perseverate about feeling guilty, particularly now focusing on the post-incarceration state, where he would turn situation, he would get stuck on situations, turn them around, and make himself feel bad about them. And she addressed fixating on confessing to the murders as a perseveration that she identified. His physical and mental decline were distinct. She said the first 4 months at Westville, he progressed from having anxiety and depression to wanting to hurt himself, to psychosis, hallucinations, and beliefs in things that aren't true. He was also expressing emotional disturbance through things like mumbling, eating the feces, banging his head. Ms. Diener objected to hearsay at this point. Mr. Rosie said it's her basis for her opinion. And at this point, the judge instructed the jury that it is not substantive evidence that they're to consider. So not that it's true. I mean, we've already heard that it's all true. At least if we are going to believe the state's witnesses, the state put them up on here, but now they don't want the jury to believe it's true, I guess. I don't know. So based on that, she concluded that he has decompensated both physically and mentally. Fifth is her diagnosis. She thought that the totality is consistent with major depressive disorder. And when major depressive disorder is at a severe level and combined with a high level of stress, that can lead into a psychotic state. And so she believes he suffers from major depressive disorder with psychosis. We heard about this from Dr. Walla in response to a jury question about the possibility of recurrence of psychosis. She had kind of, as an aside, brought this up, and it was a little bit out of the blue because she herself had diagnosed brief psychotic episode. But she did address this alternative diagnosis in that jury question. So it did lead me to suspect there probably is going to be an alternative diagnosis, and lo and behold, indeed there is. The last conclusion that she drew was about etiology, which she did not define, but it just means a cause. What's the cause? How did this condition come about? And so she said that with the major depressive disorder plus psychosis, it's when you have a fragile egg like Rick, the increased stress causes decompensation. He has a hard time when people don't think he's a good person, when he's separated from his wife, the solitariness, the being in isolation, and the incarceration being new. She says that these can actually change brain chemistry. So like a physical type of change in brain chemistry that will bring on psychotic symptoms. She next talked about reviewing handwriting samples. And so the court was, the defense proffered an exhibit, GGG, that was the letter that Richard Allen wrote to the court back on November 9th of 2022. This is in the court records. We have seen it before. And it's basically him asking for help because he doesn't believe he's been appointed attorneys yet. He's been out there at Westville for a while and he's getting a little bit nervous. Ms. Diener objected to the foundation at this point concerning handwriting analysis, so she wanted to ask some foundational questions. And so Dr. Westcott explained that handwriting analysis is part of their training in neuropsychology. There are specific handwriting disorders they are trained to look for, and also how intense stress in certain conditions can change a person's handwriting. So this largely established her foundation to be able to do that. They're specifically trained to do it. And so Exhibit GGG was provided to her. She said when she saw his first written confession, she had asked for an example of like his handwriting prior to this point. When asked if it came from the defense, she said that she had gotten the letter, she believed, from Kathy before incarceration, or she had gotten the letter to the court from Mr. Rosie. She had also gotten another letter that he wrote to Kathy from before the time he was incarcerated. Ms. Diener then objects as to hearsay. Mr. Rosie says it's not being offered for the truth, which it is not. It's being offered to show the contrast in the handwriting, as well as the change in thought processes between the current writing and the later writings. It was also part of the exam. It was filed in court months ago with the evaluation that included an image of the two writings, I think, side by side. So at this point, the judge did call for a sidebar. Ultimately, the letter was admitted but redacted. Presumably, he's making statements in there that about maybe he didn't do it or he's innocent or something like that, that they're going to cross that part out and not let the jury see that. Of course, since we don't get to see the exhibits, we don't know what was redacted or how much was redacted. So without discussing the words, like the content of the letters, she's looking at things like the structure of the letter and its visual appearance. She says that you can see the thought processes through the spelling, punctuation, the intelligence that's reflected in the writing. And so she's looking for things like intelligibility, sentence structure, grammar, and so forth. So the comparison was drawn then between this November letter and the confession letter. She says that they show very different handwriting. The later confession is very disorganized. The letter structure itself, the grammar, and the punctuation are off. There's a difference in the signature. And studies show that changes like this can happen. This is quite typical. And so it was revealing fragmented thoughts and incomplete letter structures. She identified the State's Exhibit 292 as the letter that had been addressed to the warden that she compared his previous sample to. We then got Exhibit HHH offered. This was a printout of an objective personality measure that she did, the MCMI. She said there are two different instruments that she typically uses that are comprehensive tests. They are hundreds and hundreds of true or false questions that relate to symptom presence. These tests will help to reveal personality features, which she described as lifelong features that we all have that tend to be stable over time. And the example that she gave was, for example, if somebody is introverted. The Big Five personality is like the one that I'm most familiar with. They use the acronym, the OCEAN. It's openness, conscientiousness, extroversion, agreeableness, and neuroticism. And so these are just different kind of measures where people will fall, more open, less open, more neurotic, less neurotic. Neurotic in this situation, just generally, broadly speaking, means anxious. The test will then evaluate essentially every kind of mental health disorder, taking information from these many responses to evaluate the presence of a disorder. And the test also accounts for malingering. So there are different ways that questions are asked to determine if the person is faking or if the person is underreporting, because again, they need to know that the information that they're relying on to draw their conclusions is good information. Ms. Diener objected to this. Her objection was that this was only one tool of many that were used, that the state asked for the tools and they were denied access. They wanted to have their own psychologist interpret it, and it would be inappropriate for the jury to do so. Mr. Rosie said they never even took her deposition. The defense filed and gave the state the IME report, the independent medical exam is what they're referring to it as, months and months ago. The case law says that this particular measure is, or a similar one, the MPI, is admissible as part of what she's relied on in the course of her evaluation. Ms. Diener then says that after they got the report, they asked for 12 instruments and results and was told they could not have them unless they were sent directly to the state's expert. This is one test and others could have been different. Mr. Rosie says, we gave them the examinations in a 135-page report. The judge says, well, discovery is reciprocal, so she doesn't admit HHH. And Mr. Rosie says, that's fine. We'll do it this way. So he just asks her for the conclusions from the measure that the instrument that she performed. So based on that, first, there was no indication that he was not telling the truth or being straightforward and honest in that test. So nothing triggered on the malingering measure. Personality, she talked about personality traits versus personality disorders, that you need to understand the person's personality in order to understand how stress might lead to decompensation. In Rick's case, he was extremely dependent on others. He's more passive. He avoids conflict and confrontation. He has a strong fear of abandonment and rejection, and he tends to be quiet or pull away from conflict. She said it was actually more like 25 tests that she did. Ms. Diener had said 12. She's like, actually, it's more like 25. But one test might have different components. So what she's doing is comparing and contrasting them all, looking for consistency between tests that measure similar things. She prefers the MCMI, says it does a better job of addressing personality factors than the MSPI, which is the other one. And she found consistency regarding his state of psychosis. So she described Rick as having little emotional reserve. And so when stressed, he would be more likely to decompensate to psychosis. She started seeing changes that led to her having concern about decompensation from as early as the December to March period, where he became less emotional, less expressive, less reactive, slower thinking, and he began to start the mumbling. And then this escalated to the more blatant symptoms of psychosis in April and June. Following that, he had some improvement but going forward, but some residuals, not full psychotic disorder she felt after June or July. The issue with the like lowered emotional expression, she described as being a negative symptom of psychosis. She looked at for objective tests of personality and cognitive functioning. She said there are maybe 30 different ways to look at faking in those tests, and there was no indication of faking it in any of them. Asked about serious mental illness, SMI is the acronym that kind of gets used. She is familiar with it in the context of the prison system. Ms. Diener objected to this, except as to the Department of Correction policy. That's the only thing that's relevant, and didn't think that she's qualified to talk about that because there is a misapplication in the clinical setting. So the expert responded that it actually only exists in the prison system, this concept, and she is quite familiar with it. Asked if there's an equivalent in the clinical setting. Ms. Diener objected again. That was overruled on the grounds that this goes to the weight. So she says that the kind of guide that psychologists use is the DSM-5, and they have a category that is for severe or chronic mental illness that is relatively equivalent, and that Rick fell within the serious mental illness definition. She reviewed Dr. Walla's session reports, thought it was, could not estimate like really how many it was. She thought maybe 30, but it would really be a guess. Looking for whether there was any reporting trend from her or how she was reporting these confession statements. So a hard thing about medical records is that you're reading through another person's observations. She said you rarely see long quotes in reports like this. So the confessions came across as if it was telling a story. It had a beginning, a middle, and an end. At the same time, she's looking at the other information and the reports from the suicide watchers and the videos showing that these are much more fragmented. His statements are much more out of context. They're not logical and organized. So she says there is a contrast between what Dr. Walla was writing and what she was seeing from the greater context as a whole. So in conclusion, she felt that he was put in a stressful situation away from his family. She likened the response to similar to a fight or flight. For someone not like him, it's not just the confinement or being in solitary. He's also got the other inmates yelling at him, telling him to kill himself, calling him a baby killer. The sensory deprivation, the lights being on all the time, not sleeping many days. She says the notes indicate sometimes he would only have slept 1 hour for several days, and that he was losing a substantial amount of weight. Brain changes can result from rapid weight loss as well as not knowing night from day. This can lead to changes in the brain that make it hard to distinguish reality from not reality. Mr. Rosie brought up that we had a question from the jury about delirium and asked if she could tell the jury what it was. Ms. Diener objected to this because their testimony said he didn't have it. That was, overruled. I mean, it seems like a bad thing to object about in front of the jury. Like it was their question. They wanted to know about it. But in any event, she went on to testify that delirium can be caused by a physical condition, but it can also be caused by medicines or substances that can leave you in a confused or disoriented state. Delirium is in the DSM, and she also testified that sensory deprivation can lead to delirium. She had a concern about delirium for a couple of reasons. One, because prolonged solitary confinement can lead to delirium. This is apparently well established in the literature. And she also saw him drinking toilet water, eating feces, and not eating. These things can lead to infection in the body, infectious processes inflammation processes, and that can cause some concerns as well about possible disconnect from reality. Ms. Diener then took the cross-examination. So she first turned to the questions of solitary confinement and sensory deprivation, asked if this would involve any circumstance where sensory input was limited. And the doctor testified that this would a person normally would have physical contact, conversations, their own space, whereas in the solitary, they're in a very small space. The lights are on all the time. There's a limited view outside. His window apparently was very scratched, and so he couldn't, really have much of a view outside of the window either. And that there's documentation of this phenomenon in studies of prisoners of war. Ms. Diener says, but Dr. Wallace saw him every day. Mr. Rosie objected to this, saying that she had daily visits where she would just go to the door, and that mischaracterized the evidence. Ms. Diener responded that her records reflect the visits would be for 15 minutes to 1 hour, and that was a different thing from the mental health practitioners who would just stop at the door to check in on him, and that her notes showed that in the exhibits. So Dr. Westcott explained that she remembered reading that Dr. Walla would go to the cell on many occasions and he was not responsive. So based on that, it was not her understanding that she saw him daily for an hour. Sometimes she did. Other times she was unresponsive. She reiterated that the 30 to 50 days of the reports that she had estimated was a very rough estimate because there was an enormous amount of records, but she had seen notes where Dr. Walla was reporting that he's unresponsive. And so she doesn't consider that a session. If you're not meeting with him, he's not responding, she wouldn't include that in her count. And so Ms. Diener she's employing this very Kathy Newman style questioning. If you don't know the Kathy Newman reference, this is a fairly well-known interview that this British journalist Kathy Newman did with Jordan Peterson, who, like him or not, handled this interview, I thought, very well, because what Ms. Newman would do that thing where, the person is talking to you and then they're like, so you're saying, and then grossly mischaracterize it. And Jordan Peterson, would explicitly call out, no, Kathy, that's not what I'm saying. What I actually just said was this and that. So I noticed that because that's essentially what she was doing. She was trying to mischaracterize her testimony to suggest that, she had incomplete information, or maybe she didn't look at it all or something like that. Ms. Diener reiterated that she had looked at all the records. She would refer to notes where there was information, and she would exclude ones that she did not consider to be a session because he was unresponsive. With respect to the window being scratched, Ms. Diener's like, and that came from Mr. Allen tell you that? She says, I'm basing it on the medical records, not on anything Mr. Allen told me. She was aware of reports that the light switch could be dimmed. She was aware that he had the ability to leave the cell for rec, for showers, to have his vitals taken, and that in all of these cases, it did not occur every day. She's asked, was that also based on incomplete reports? And she responded, she has reports from every day that he was incarcerated, but many times he was refusing because he was in fear of leaving his cell. She's asked, did counsel tell you, what they wanted you to say? No, she got no information from counsel regarding their opinions about his confessions. Her conclusion that many aspects of his confessions were inconsistent with known facts were all based on the medical records. Ms. Diener's trying to gotcha, but you said it's inconsistent with known facts, but you also said you didn't know, they didn't tell you about the case. And she said all of that is based on the medical records. For example, a time when he was saying that Satan killed the girls, and she is perhaps going out on a limb concluding that Satan is not in fact the killer of the girls. But so that was a factually factually inconsistent, a response that is inconsistent with known facts. With respect to exaggeration and malingering, she said that there was no evidence for deception and malingering throughout the cognitive testing. That means he's not faking. Asked if Mr. Rosie was there, Mr. Baldwin, she said the attorneys were not there at all for the testing, as Ms. Diener is trying to imply they influence things. They weren't there at all for any of the testing. She described there was somebody who took her over inside the prison to the MCU. She met with the superintendent, and they took her to an office there. And so then asked if Rick knew that she was there with the defense. She says she has like a typical kind of script that she uses. She will ask if they're aware that she's going to be there, that she's there to do an evaluation, advise them that there's no confidentiality because it is part of a legal process and he can decide, he can choose whether or not he wants to participate. And specifically as to the part about cognitive testing, she agreed that it was an accurate reflection of his mental condition as of the time of the testing. She agreed that Dr. Walla had said that Mr. Allen had dependent features, dependent personality features or traits, and that she related that to his wife. She was asked if it's possible that he can transfer that type of dependency, that attachment to somebody else. And the doctor said that is not likely when you're attached to somebody for decades and still are continuing to have some contact with that person. It is not typical to move that dependency from person to person. And then specifically with Rick, he doesn't typically associate with or cling to others. So he sounds like he's got a fairly, close circle and is not necessarily real open to people outside of that. So she asked if you can conclude from how he behaves toward people that a person is in his inner circle. So, for example, if Dr. Wallace says he's saying things like, "You're like my wife, please don't leave me. There's things I need to talk about, and only so many people I can trust." What does that mean? And she says it's not necessarily a transfer of that dependency on his wife to Dr. Walla. It's literally she's just one of few people he can talk to at all. He has this abandonment fear, and so she's one of the few people available in prison that he can actually have a conversation with. So no, she concludes he did not transfer those dependent personality disorder features, but that doesn't mean that he didn't talk to her about things. When asked about malingering, she acknowledges, yes, people in a criminal setting may seek to avoid consequences by faking. I made a little note in my margin about this because, Ms. Diener was objecting on direct to, we can't talk broadly about things. We need to limit it to very specifically to Mr. Allen, because of course that's the relevance framework that Judge Gohl has laid down and is largely abiding with. But here she is asking broadly about people in criminal settings where she wants to get into the concept of faking. She did acknowledge the doctor that some of the videos she watched had timestamps, but some didn't. With respect to both Dr. Walla and Dr. Martin, she agrees that they were both observing his behaviors and she takes their observations into account. She also has an abundance of information besides them. As far as the suicide watchers go, she says they're talking about his behaviors, but they don't diagnose. So she's giving them some weight. But, the whole thing about how he's not genuine or whatever, she is probably not relying heavily on that because that is not their role. And she has her measures to determine that. She said she was not aware of the details of the homicide investigation. Concerning Dr. Walla's diagnosis of brief psychosis with related stressors, this is a DSM-4 term. That's not in the latest version that's been out for many years. Currently, the major depressive disorder with psychosis is included in the current DSM-5, and that change was made around 2015. She agreed his psychosis was not necessarily as prevalent after, say, May to June. She says that psychosis is usually a gradual onset. When a person is in that state, they can be saying things that are close to factual or not, but the majority of what they are experiencing is not the same reality as you or me, but they can answer questions and provide a factual answer. He had disorganized speech that was documented. That's just one symptom that can be seen. There are many others. He couldn't put together multiple sentences at the same time that would follow a logical order. Asked if she had the April 5th and May 3rd confession statements. She said that yes, she did. Why didn't she? Well, she said that she's trying to put the key factors in the symptoms or changes that are part of her evaluation. So she's looking for unusual factors or statements that reveal his mental state. So the 4-5 confession statement wasn't summarized in her report. She said that this is in Dr. Walla's writing. It's not in quotes saying that it's exactly what he was saying, whereas other confession statements in her report were contained in quotes. I did notice at this point that one of the jurors was doing a very slow blink at Ms. Diener and all this, like maybe not liking the Kathy Newman routine. I don't know. Then on May 3rd, she agreed that there was another detailed statement, and the doctor said that her job was to discuss and evaluate the symptoms for changes in his behavior and thinking. So she's describing what he's displaying that tells her he's still having a psychotic state. Then Ms. Diener says you didn't note that she said she wasn't identifying psychotic symptoms present at that time. The doctor says, I disagree. She is bringing up brief psychotic episode and describing psychosis symptoms in what she's writing. And that is correct. We know from the 5-3, that was when the diagnosis was made, and there was the addendum report that included, as she described it, the criteria for the diagnosis that she was making. So yeah, that would seem to be inconsistent if she's saying she's not identifying psychotic symptoms, but she is, diagnosing him with a brief psychotic episode. On May 10th, this was the incident when he had asked Dr. Walla to stay in the room while calling his wife, and that he told her he did this, and I think I'm losing my mind. When asked if she listened to the phone call, she said she listened to the majority of the phone calls that he made to his wife, but she doesn't remember specifically if the date was that May 10th day. And at this point, I'm noticing another juror is kind of giving narrow eyes to Ms. Diener. That was the conclusion of the cross-examination. We then had jury questions. First question was that you stated he had fears of leaving the room due to threats of leaving the cell. If he had the common sense to not leave his room due to fear, does he have the common sense to fake his symptoms? And the doctor said this is actually a very good question. When he was reporting the fears of leaving his cell, this was in the December to March period, where his behavior was starting to slow, his thinking was starting to slow, and that's when he was reporting the inmate behavior and the fear associated with it. Next question was, if someone has depression or anxiety as a child, will that cause them to commit murder as an adult? She said that would be more about personality features, that people who commit murders, there are people who commit murders who don't have mental health disorders. Generally, people who are passive tend not to be aggressive. Aggressive behavior that is observed during a psychotic episode would be different from the type of thing that you would be looking for in like normal life when it comes to evaluating personality. And that's because that's consistent with what she described before. You're really looking at the long-term fixed pattern and not the situational type of response that a person might have. His personality tests that he took look at passive versus aggressive tendencies, whether it was consistent, and that it was consistent with information that was taken from both him and from his wife, that he tends to be more passive or submissive. And so asked if, if there would be something about him being aggressive later, would that change it? And she said she would want to know more information about it if it was related to like aggression towards himself, a self-harm situation, and also if it was before or during his incarceration. This was clearly Ms. Diener trying to open the door to get in that video that they had tried to introduce before from him in Cass County. And so I don't think that this is probably going to do that because she did say, well, it would depend on, incarceration status at the time that it happened. Presumably because that's remaining stressful and separated from his family and so forth. These are the same conditions that would tend to generate, like the same behavior that we saw at Westville. And so it doesn't necessarily undermine conclusions long-term about his long-term personality features. Next question was, if someone has depression or anxiety as a child, would that cause him to be a sex addict? And she answered, no, I don't think I would agree with that. Asked, did you watch his October 2022 interrogation statement to police? The answer was no. She did not watch that one, which is interesting. Asked, in your opinion, is his diagnosis major depressive disorder with psychotic features and not a psychotic disorder? So she distinguishes between these where with the major depressive disorder diagnosis, it's when he has major depression that when severe, it can become, he will have psychosis. Psychotic disorders are different. It's more like schizophrenia, where psychosis occurs outside of the context of being depressed. Ms. Diener followed up to ask if major depressive disorder and psychosis is over a period of time. This is probably not a prudent question for her to ask because the answer that she got was not necessarily. A person who has this diagnosis, who experiences a psychotic break, is about 25% more likely to have psychotic episodes going forward, and that once it happens, they can then have later ones when stress arises. Also, that psychosis can ebb and flow going forward. She noted that you can treat the depression, and that tends to help the psychotic symptoms. So this, I think, was Ms. Diener trying to shoot for that February 24th, 2024 statement that the one guard over in Wabash claims that he made. That statement, the guard had changed it during the course of writing it down in his log and then later reporting it to law enforcement. So probably wanting to suggest that that didn't happen when he was in a psychotic state, but this answer seems to suggest, could be, because it's, now it's going to be something that he may have to deal with when he's dealing with stress situations. Question, can the objective testing be interpreted multiple ways? She said, no, not really. There is a pattern that's very well known and accepted in the field. She described the interpretation of these tests as being like a cookbook. And so there is not typically a lot of variation among psychologists about the results to these measures. Did your medical records prior to incarceration include any objective testing by those who provided the medications? She said, probably not. She'd say no. It was mostly self-report. There were occasionally ways to kind of scale things, that he would scale things to see if the treatment was helping, having him rate his symptoms basically, but that is essentially subjective in nature. I would have liked to have seen a follow-up on this, mainly because it's my understanding, my impression that testing like this with these measures is very uncommon in a clinical setting. These are primarily forensic tools that are used in that context. So it's rare that like you would go in for therapy and they would have you like take the MMPI. Like it just doesn't really, it's not really a thing. But there was no follow-up about that. What is the difference between delusions and delirium? So she described delusions as being a false belief and that there are lots of different types. In this case, he would feel very, very guilty about a thing that is not a fact. With delirium, it is very different. That's a state of being confused, disorienting, not knowing where you are, not knowing the time of day, not having an accurate perception of what is going on around you. That was all the jury questions. We had a sidebar at the conclusion of that testimony. We took the morning recess at this point. So the morning recess was a little bit late. It took place about 11 o'clock today. I just stayed in the room. I didn't leave. They were, during this time, setting up the screen, like moving it back over, making it clear. We're going to be displaying more video only to the jury. But then as people began to come back from the break, they were reporting that there was already a large crowd of people downstairs for lunch. So a couple people went ahead and left at this point in time and went downstairs and stood in line for lunch. Before the jury was brought back in, the judge addressed the state's cumulative objection as to the videos being played. She said she had overruled it as to the movement video. And in the event this additional, the in-cell video starts to become cumulative, she would ask for a sidebar. Mr. McLeland asked for procedural clarification. Is the plan to play the videos and then let him do his cross then? And the judge says, yes, you can cross him then. So Max Baker is recalled to the stand. He said that previously they had offered up some movement video to the jury. This is a second set of video that's been extracted from video inside his cell. This was all received from the Indiana Department of Corrections. Clarified there's no audio with these videos. It hasn't been tampered with or anything. They don't come that way. And that these videos, unlike the movement videos, are date and time stamped. So he described how he condensed these videos. He said that they had generated about 20 hours and reduced it to basically save time for everybody. So we don't have to watch 20 hours of video. He picked out the two videos that he thought were most important. These videos had come in 5-minute chunks, which was not consistent with like all the videos that they were produced. Some of the videos that were produced came in 24-hour increments in the native format. So what they would have to do is drag and drop each chunk, each 5-minute chunk into this continuous format, basically to clean it up to be one continuous video. Because of that, you would be able to see cursor movement going on the screen. So basically they just did this and then screen recorded their own screen while it played. So this was Exhibit III, the thumb drive that contained videos from 2 to 7 p.m. on April 12th of 2023, and then 8 to 10 a.m. on May the 25th of 2023. They had also fast forwarded through the video so it would speed up. They chose to just try to accelerate it to the point where it would move and you could still see what was happening, but it wouldn't corrupt the video to where it kind of starts to skip. And that was just a subjective decision they made based on where they thought it was not really affecting the viewability. As far as the total videos that they do not have everything up to the present day. He says they have up until July of 2023 from Westville, the last that he had seen. Mr. McLeland at this point notes his continuing objection. And the first video is played. So once again, can't watch the video, so I watched the jurors. The jurors started off once again very, very deadpan, like probably even more reserved maybe than they had started off the last time. They were not taking nearly as many notes. Several of them were leaning forward, so still kind of showing attentiveness. The juror who was historically the most responsive is now also taking the most notes during this. And then it takes a while. They're watching this just flat deadpan for a while, quite some time, and then at one point, number 6, the juror, he puts his head down, rubs his head, puts it back up, and does kind of prayer hands over his mouth. His head drops again. He rubs his head again. He looks over in the direction of either Rick Allen or the prosecutor, can't really tell. And then he looks over to the right away from the screen. At this point, I see that the juror who had previously been doing that really slight rapid rocking is doing that again. Now I see that the responsive juror has taken on a very slumped posture, is blinking, looks down and kind of works mouth, looks back, looks down, shifts in the chair, has a hand over the mouth, and is looking down over to the right. I see the juror who has the very pronounced mouth shrug. This one is making that expression. I see another juror lean back in the chair and cross the arms. The responsive juror is continuing to will check in and look away, closes his eyes at one point with his hand over his mouth, looking back away at the other direction, looking down with his hand over his mouth, looks up towards Rick or the prosecutor again, is just looking, like checking up at the screen, and looks down, closes his eyes, head down, rubbing his forehead, keeps looking up to check, puts it back down, rubs his forehead, looks up to check, down, rubs his forehead, and closes his eyes. One of the jurors in the same row as this juror now turns and looks down the row at that juror, kind of doing the check-in on him. So he's continuing to do the same thing, looks up, head back down, rubs his forehead, and does a like tucking your cheeks back kind of reaction. It reminds me of an expression my dogs make sometimes. You know, I don't know if your dog, when it looks like your dog is smiling, your dog is like not really smiling, but they're just kind of like tucking their cheeks back. It looked like that. Checks back in at the screen, puts his head back down, rubs the forehead, up, back down, up, rubbing forehead, back down, keeping his hand on his forehead now, just keeping his head down with his hand on his forehead. Really can't watch a lot of this stuff. It's like checking in and just continues to look away. I noticed at this point that Mr. Luttrell is watching the video, and he's kind of scowling a little bit, like it looks like his brows are lowered and he's got his own mouth shrug, his lower lip is pushed up, kind of that kind of expression. We then move on to the May 23rd video. So now the juror who was previously having difficulty watching, he's watching again. He's actually like leaning over to see and taking notes. So very attentive again. I see one of the jurors who hasn't previously been super reactive start to rub her forehead and her head and her nose in this very quick succession. Juror has fingers over her lips. Our responsive juror takes a look over towards Richard Allen or the prosecution, blinks, and looks back at the screen. One of the jurors who's been one of the most prolific note takers through like the entire course of this trial is now sitting back with arms crossed, not taking any notes at all. Our responsive juror does now, I describe it as he presses his lips together and juts his jaw forward a couple times. So it's like jutting the jaw. Then moves the hand back to the mouth. The juror who has not previously been that reactive does some hair adjustments and shifts in the chair. A reactive juror is now sitting with the hand on the chin, and our other juror is adjusting the hair again. And then I notice is holding the pin up like a kind of like a spear, like it's pointed out. Normally, this juror is seated in a just normal, relaxed. So this hand up pose is different. I see a juror tighten the mouth, so just that tightening of the mouth. I see the juror who has not historically been very reactive do a chewing motion and look down. At the same time, the juror who tightened her mouth before does it again. Our reactive juror has his hand back over his mouth and scratches his head, and then scratches his cheek and looks away. Another juror has fingers over the hand and mouth. And then our reactive juror closes his eyes, raises his eyebrows, leans forward, and does a little head shake. And then I see another juror who hasn't been particularly reactive give a very deep sigh. And that's at the end of the video, like as the video is ending, just like you can visibly see the movement of the body. Mr. Baker concludes that of the in-cell video, they had compiled about 18 to 20 hours worth of video like what they had just seen, consisting of others that were in April and June, similar videos, and others leading up to the period of time that was shown on this screen. And with that, his direct was concluded. The screen was taken back to the other side of the room. And Mr. McLeland set himself up for a real FAFO moment. Sometimes the challenge in trial is the discipline of knowing when not to ask the last question. This is something that it's a common pitfall. The defense has done it in this trial. The state has done it in this trial. The most skilled cross-examiners know when to stop, and they know what the difference is between eliciting the facts that you need to be able to present an argument versus asking the witness to try to confirm that argument for you, because they will never do that. They will always be resistant to the conclusion that you're drawing when they're the hostile witness. So you don't ask them the therefore part of the question. You just save that for when you argue it. You have the facts. You point out to the jury, they said this, we're reasonable people. Here's what that means. Mr. McLeland first asks, in the video today, Mr. Allen is in a cell. He has a cell all to himself. Do you think it's safer for him to be in a cell by himself? Mr. Rosie objects to this as being beyond the scope and not having any foundation. That objection is sustained. Asked how many hours of video he watched. He said probably hundreds. He hasn't seen every single one. They are, 24 hours of video, some of them. And so it would not be feasible to watch every single one. But he had seen, he thought, a substantial amount. Mr. McLeland says you picked 15 of the movement videos, and of the in-cell videos, you chose 2 that you thought were the most important. He confirms that and says, I can expand upon that if you'd like. And, you put him on the spot. Now, what do? Say, no, you can't expand on it. You look like a jerk. You look like you're hiding stuff from the jury. Some people will do that. I mean, we've seen that happen. I think Mr. Rosie has done that a couple times with cross witnesses. I think with Mr. Mullen, maybe. No, because I think Mr. Baldwin has handled Mr. Mullen. Anyway, I do recall Mr. Rosie doing that on cross a couple times. And they're like, going on like, no, don't need to. Well, Mr. McLeland didn't want to do that. Like, go ahead and expand. Well, it's not always a wise thing to do. So he said he chose these videos because he thought they showed different aspects of Rick's life in prison. They showed him meeting with Dr. Walla. They showed him getting showers, getting an x-ray, getting tased. he thought that these were a true reflection of Rick's mental state. Mr. McClellan says, you chose these specific videos to try to curry sympathy with the jury. This gets objected to, and they come back to it, and he asks it again. You're picking these to try to curry sympathy with the jury. And Mr. Baker says, I could have picked a lot more videos, and they would have been just as bad. In fact, I wanted to show more. Mr. McClelland then says, you're trying to show that Mr. Allen is the victim here. He says, I'm trying to show an accurate representation of his time at Westville. And Mr. McClelland's like, well, you picked out the worst of the videos. And Mr. Baker said, I didn't say I picked out the worst. I said the most important. Mr. McClelland says, do you agree, basically, Richard Allen isn't the victim here, Abby and Libby are? And he says, yes, there is, in the meantime, an objection to relevance that is sustained, but he does say yes. Mr. McClelland says, you could have shown the other videos. And Mr. Baker says, well, you could have not objected. Touché. Touché. As far as the ones he did show, the 2 incel videos, they showed events that have been referred to throughout this trial, including the eating feces and the banging head. And Mr. McClelland says, you didn't show the jury other incel videos. And Mr. Baker said, yes. And as far as I can tell, you didn't either. Young Mr. Baker is quite a ninja. I don't think Mr. McClelland saw that coming, and this is just probably an example of where you should have just argued these points to the jury instead of asking the witness to try to confirm your theory. Of course he's not going to confirm your theory, and he just handed you your entire ass. So that was quite a boom moment that landed on Mr. McClelland pretty hard. He had no further questions after that. Probably not the best place to end your cross-examination, but when it's going that badly, I guess he had the smarts to know time to stop digging. So we should probably give him some credit for that. There are some jury questions. While the jury questions are being handed up, I noticed 2 of the male jurors are kind of talking to each other and laughing. Don't know what about, but just saw that little interaction, had some kind of comment between them. The question, since you worked for the defense, did they prompt you to choose the worst videos? And the answer was, I had discretion to choose. I compiled videos from December forward that had, nothing going in the cell. And up to Saturday, I was planning to show them. Then Mr. McClelland followed up asking if he had, heard the phone calls with the confessions and if any of these videos were on the dates of those phone calls. And he says, I don't have those dates in front of me. I don't know if those are the dates of the confessions or not. So then we had our lunch. As we were breaking for lunch, Mr. McClelland said that there were witness issues that he anticipated coming up, so he requested a sidebar. During this sidebar, being aware that there was already a crowd, growing in the area below where we have to wait for after lunch, people started to leave the courtroom to go down. So decision was made. Not going to stay for this whole sidebar. I can't hear it anyway. Going to go ahead and go down and try to get my place in line. And it was a massive crowd. This was the first time that I was not going to make it in. Had not somebody already down there waiting in line, Truth Seeker and her friend. Thank you so much. Thank you. Her friend offered me his place in line. And so because of that, I was able to get back into the courtroom after lunch. There is starting to be a little bit of chaos and drama and stuff concerning, the general rules that everybody has been following about how the line sitting is working. how like it's okay if somebody is going to hold a spot in line for you, but that means that you are swapping out. It is not that people can save a place for you and then, more people going back into the courtroom than were originally in line holding that spot. So a little bit of drama over that. I'm not going to name names or anything like that, but just that is starting to happen. The civility that I thought we had so far is beginning to deteriorate, and that's very unfortunate. I did see that lawyer Lee barely made it in. She was not going to make it in. I was actually number 24. I was the very last one to make it in, like the initial part. So Truth Seeker then also gave up her seat for Lee. I got Truth Seeker's friend's seat. Truth Seeker gave up her seat for Lee. So Lee was able to get into the courtroom. I was approached on the way up by a gentleman in a suit that I had seen in the courtroom before. He was there when the Hammond County police officer Goatee, or Sheriff Deputy Goatee, had testified, where he, didn't remember anything about the interview of Brad Weber, even after he reviewed the FBI report and said yes, it refreshed him, but then he didn't remember Brad Weber making the statement about going to work on the ATM machines. This gentleman had been present during that, so I had assumed he was a Fed, but I don't know. But anyway, this gentleman came up to me, handed me this lovely Sharpie S-Gel pen, and said, "Andrea, give this a try." And so I did, and I gotta say, this is an extremely nice pen. I might actually like this better than my Uniball Vision Elites. This is a very nice pen. It's a 0.7 thickness. So a little bit of a bold pen, not like a thin little scratchy pen. I can't stand those. It's like something about the sound and like the texture of it scratching across the paper that just really irritates me too, with like a really fine point pen. This is a nice bold one. It's a great pen. I might actually switch. Like this was a great gift. So thank you, mystery man who gave me this pen. When we got back in, the judge said that she had reviewed a report provided by counsel. It falls within the hearsay exception for a report, but it contains what she would call totem pole hearsay. So unless you can provide an exception for each statement, and then kind of trails off. Here's what this means. Hearsay can be in many different levels. When you have a written document, that written document itself is hearsay. But the document may be able to be gotten in under some different kind of hearsay exception. Business records, we've seen a lot of. Medical records is a common exception. Sometimes like journals, like contemporaneous recordings of things can be an exception. But then the document itself can also contain information about things that people said. And so that's hearsay within hearsay. And those statements within the document don't necessarily come in just because the document itself fits within a hearsay exception. And that can go on many levels. You can have a statement about a statement contained within a document. Now you're, third level hearsay. And the rule is that you do have to establish a hearsay exception for each level of hearsay that is contained in what you want to admit into evidence. So don't know exactly what this report is. I suspect it's the FBI's 302, but I don't know for sure. Ms. Auger started off the testimony after lunch by calling Jamie Jones. She is a sister of Rick. They have different fathers, but the same mother. Rick is about 5 years older than her. They had always lived together during their childhood. He left pretty early, around 18, when he went to basic training, and then he got married shortly after he got back. And so he was gone from the home twice for a military, and then was in the reserve for a long time. When asked specifically, Ms. Auger is apologetic about having to ask this question. Did Rick ever molest you? No, he did not. He never touched her sexually. Asked, does she love him? Yes, she does. Asked, would she lie for him? No, she would not. Mr. Luttrell then asked, is he a little over 5 years younger? Yes, confirmed. She's a little over 5 years younger. Asked if there were a lot of neighborhood children around when they were growing up in Mexico. Yes, they were Mexico, Indiana, not Mexico, Mexico. Mexico, Indiana, right north of Peru, Indiana, I think. Maybe it's south of Peru. I don't know. Anyway, it was off. I saw the signs when I was coming back from Fort Wayne. There's like a sign going one direction for Peru and a sign going the other direction for Mexico. And I'm like, this is not right. But anyway, that's where they grew up, was in Mexico, Indiana. So he asked if a child was named Chris. At this point, Ms. Auger objected, argued that it was beyond the scope, and that objection was sustained. So Mr. Luttrell was clearly trying to imply that even though Rick's confession that he had molested his sister was not true, according to her, fact not consistent with what he's reporting, that maybe, some of these other names that he had thrown out while he's psychotic, maybe it could have been them. Desperate. That was beyond the scope. It was sustained, not allowed to ask it. He had no further questions. The next witness was Brittany Zapanta. Brittany identifies herself as Rick and Kathy's daughter. She lived with her parents her entire childhood. She moved out around 2015 when she was working for a job. She said what she worked at, but I could not catch what she said. She said she worked at a something, and I don't know what that was. She was gone for school at Ball State for a year at 18, and then was also in Indianapolis. She did graduate from high school. Again, very apologetically asked if her dad had ever molested her, and she kind of smiles and says, no. Asked if she loved him. Yes. And she looked right at him, like after she said that. Yes. She loves her dad. No, she would not lie for him. I did see before I came on stream that there has been apparently a flurry of false reporting about all this. I'm aware that it's apparently been like a, I don't know, storyline or something that like Brittany hates her dad, and Brittany hasn't been coming to court because she hates her dad, and Brittany won't make eye contact with her dad and stuff like that. Appears to be unequivocally untrue. She displayed very loving demeanor towards her dad. She did remain in the courtroom after her testimony was concluded. Kathy was not in the courtroom all day today. I suspect that may have to do with the fact that the seats, it seems that the defense seats are now being limited. They're not getting the full allocation that they were entitled to in the order. I did not expect Kathy to be there for the videos being played, just like she wasn't there. She wasn't there when that happened before. But otherwise, she potentially could have been in, but she was not all day. Brittany, however, remained in the courtroom after concluding her testimony. Mr. Luttrell asked if she would go to the trail often. That was objected to as beyond the scope, and it was sustained. Then asked, did you go to the Monon High Bridge? She objected to that as well as beyond the scope. That was sustained. She was asked, from the time that she went to Ball State to later, did Rick's appearance remain the same, and just clarified his same height, weight, etc. remain the same? Yes, she said that it did. He handed her what they introduced as exhibits 306 to 309, asked if they were a fair representation of how he looked soon after she left for college and continuing to 2018. Ms. Auger asked for a sidebar at this point in time, and they had a short sidebar. She asked some preliminary questions of the witness, each exhibit at a time. Do you know what year this was taken? No. 4 times? No. She did not know what year it was taken. Asked, do you know if this is what he looked like in February 2017? She did say yes to all of those. And asked if differences between them were because they were taken during different times in 2017. She agreed with that. Ms. Auger retained, continued her objection, but these were admitted over her objection. The state then wanted to introduce 3 more exhibits, 315, 316, and 317. Ms. Auger objected that these were beyond the scope of direct and that her objection was previously sustained. So these probably have to do with being out on the trail or out on the bridge. So now they approached again for another sidebar. And when they returned, the objection was sustained. We had a jury question. This jury is clever. Did you visit the High Bridge in your teens? State had tried to ask, didn't come through. The jury wanted to know, so they let him answer. Yes, she did. Did you cross it? Yes. With your father? Yes. Were you scared of the bridge? Yes. And then she said that she only crossed it maybe once or twice. So clearly not scared of her father, scared of the bridge, and had the courage to cross it with her father. Next witness was Shelby Hicks. Shelby is 30 years old. In 2017, she had a hard time figuring out how old she was, but eventually landed on 23. She is from Monticello, born and raised there, went to high school there. She's now a realtor in Lafayette. She remembers February 13th, 2017, because she had bought a new car and had to take it to go get fixed in Lafayette. When it was done, it was a beautiful day, so she stopped at the trails with her boyfriend, her then boyfriend, Daniel Pierce, to go hiking. And this was at the High Bridge Trails, which she had been to before, and she had seen the High Bridge before. She estimated they arrived at the trails around 2:30. It could have been a little earlier. It could have been a little later. The reason she believes that is because when she had taken her car in, she was starting to say it was done. And then she said she took it in at about 12:40. And that her dad had called while she was at the trails, and she had timestamps from that call from around 2:30. She parked at the trail connector, which she described as being in between the highway and the High Bridge. There's a house and a farm across the road. She hasn't heard it called the Mears connector before, but she described it as it has a gate that you would park in front of, and when you came in, you would be in the middle of the pathway that goes between the highway and the High Bridge. She did not remember if other cars were parked there. So she is a witness who was serially refreshed throughout the course of her testimony with her deposition. So after being refreshed, she recalled there were other cars that were there, but she did not remember how many. When she got to the connector, the High Bridge was to the left, the highway is to the right. She believed they went towards the highway first for about 5 to 10 minutes and then went back towards the High Bridge. When asked, how far did you get towards the end of the trail before turning around? She thought pretty far, then was refreshed with her deposition and said went about halfway to the highway. It took her about 10 to 15 minutes. It wasn't clear at this point if she was saying to get to the point where they turned around or after they turned around. It took them about 10 to 15 minutes. Asked if she saw anyone. She said she saw another gentleman and 2 other friends that she knew. Asked if she saw anybody else. She was refreshed with her deposition. And she clarified that toward the High Bridge, she had seen 2 friends from high school, an older gentleman and 2 kids. She described the older gentleman as having a camera. The friends were Cheyenne and Shelby Dunn. She used Cheyenne's maiden name, which I didn't catch, so I'm just saying Cheyenne in this, but it's Cheyenne. Well, now I don't even remember, from the other day. Did I write it down? Cheyenne Mill is her current name. So she said she saw them on the high bridge. She didn't initially remember who was there first, but she thought that she was. She's refreshed with her deposition. And now she recalls she was there first out on the platform on the bridge. She saw Shelby and Cheyenne walking towards the bridge, and she knew them from Twin Lakes High School. This was not an arranged meeting. It was unexpected to see them, so they just quickly said hi to each other, but didn't otherwise have a lot of extended contact. They went and walked across the bridge. Her boyfriend Daniel was on the platform with her. She did not recall if it was the first or second platform, but she recalled that they were on the right side of the bridge. And so I believe that would be the second platform. The first one, if my understanding is correct, is over on the left, and it's approximately where the now improved part of the bridge comes to its end, is basically right at the point of that first platform. And that one is on the left. So if she's on the right, it's further down. She said she saw Shelby and Cheyenne walking. Wait, hang on. So she watched them go in that direction. Couldn't remember if she saw them go all the way to the end. Asked about the old man with the camera, whether he was seen when they were approaching the high bridge. She said she thought that they were walking towards the bridge and looked back, and what she remembered was that they looked back and saw him, and that he was taking photos at that time. Being refreshed with her deposition, she remembered that she did watch Shelby and Cheyenne walk all the way across the bridge. As far as the other people she encountered, she did not remember who passed who on the way in or out. The two kids, she didn't remember where they were walking to. Said they stayed probably 10 minutes on the platform after Shelby and Cheyenne got to the end. When they were done, they walked straight back to their vehicle. Did not remember if cars were there when they returned. She's refreshed again that they were on the bridge approximately 15 to 20 minutes. She's refreshed again, remembers it's less than 30 minutes. It could be as much as 30, but not more than 30 minutes that they were on the bridge. Then I'm noticing at this point some body language from the juror who has been our reactive juror during the video watching. This juror's whole body is turned over in the direction of Mr. Baldwin. It's just something I noticed because most of the jurors, they'll sit straight in their chairs and their heads will go back and forth. But this juror now, the entire upper body is turned toward Mr. Baldwin, who's standing kind of over next to the jury box when he's asking questions to get the jurors to project their voices out. So he's to the left, and the juror is, fully turned to watch him. After getting to the car, they drove to the Amish community around Camden and then went home. The next day, they went to tell the police everything they saw after, they had learned. So they stopped at the station, and Daniel went in to talk to them. They told him to talk to them another time. So he went to work, and they ended up going to his work to talk to him there. And they talked to Shelby later that evening. On the bridge, she heard nothing unusual, nothing out of the ordinary. She has talked to the police 2 times, and that is up to this day. There was an objection. She started to say, then, of course, when we went, there's an objection by Ms. Diener. There's a sidebar. I don't know what that is all about. My suspicion was maybe sketches, something to do with sketches, but I'm not sure. I don't know. So the first time the police spoke with her was on February the 14th. Second time she thought was a couple months later, maybe in March. She's refreshed with her deposition. The second time was in March of 2017. She has not met with law enforcement since then. They never took her phone to get any information or an extraction from it. And if asked, she would have given them her phone. Today, she does not know where that phone is. Ms. Diener asked if she remembered who her provider was at that time. She said Sprint. We established that she was interviewed on February the 14th and March the 1st. She did not remember if she had referred to those statements when she was being deposed. Asked about seated on the platform, whether it's possible to see the end. And she's like a little confused. She doesn't really answer this, see the end, like with the trees. And she clarifies she's never been to the end of the bridge. She says she didn't pay attention to them, to see them while they were at the end, to see them at the end, and didn't catch them, didn't watch them while they were walking back. And they left the platform before Shelby and Cheyenne returned. There was a jury question. Was the man with the camera old? Yes. And would you say you arrived at the high bridge around 2:55 or 3 o'clock? She said it could have been, and Mr. Baldwin clarified it could have been earlier. Yes. It could have been later. Yes. Next up, Mr. Baldwin recalled Steve Mullen. Remember how things just keep getting worse and worse and worse for old Mr. Mullen? Yeah, when you're getting recalled in the defense case, that's what we call a clue. So first, he was asked, remember you turned over information about the 2016 Ford Focuses? Yes, and that the ones that had the similar body type were the 2011 to 2018 model years. The defense presents him with what they've marked as Exhibit JJJ. He identifies it as the list from the Department of Motor Vehicles of the Ford Focus SE, registered in Knight, Cass, Carroll, Howard, and one other county that I couldn't catch, from the 2011 to 2017 model years, that these were similar body models in 2017. Asked how many were hatchbacks. The code, they went through the codes. The code he relied on is P3K in the VIN, and that stands for SE. Mr. Baldwin clarifies that P3L, P3M, P3N apparently are also hatchback models of the cars. So he asked, why didn't you want the jury to see all the other similar body types? And Mr. Mullen said, that wasn't the question I was asked. Oh, look at that. It's the prosecutor's fault. Surprise, surprise there, coming from Mr. Mullen. Somebody else did it. Asked, don't you think it's important for the jury to see all the similar body types? Mr. McClelland objects at this point and says, this doesn't have a certification. Mr. Baldwin says, he's like looking at it, and he's like, oh, the ones you gave us weren't all certified, or just the ones you wanted in? So Mr. Baldwin asks how many hatchback Ford Focuses were in the area. McClelland objects to this. And Mr. Baldwin asks how many people owned similar Ford Focus hatchback vehicles in the surrounding area. And he said, I don't have that information right now. I did research that. So the judge is not letting this document in because it doesn't have the certification, because Mr. McClelland and Mr. Mullen didn't provide the certification for these ones. They only provided it for the ones they intended to get into evidence. And that was discussed in the presence of the jury. Now, he asked, do you remember the missing evidence? And that you told me you created a log of people you had interviewed that went missing. And as you sit here under oath, you say that? And Mr. Mullen says, we had created a list of people that we interviewed that we believed were lost. Mr. Baldwin asked, do you remember your March 8th testimony in Fort Wayne? He says, yes. Mr. Baldwin says, would you like to review it? Mr. McClelland now objects at this point. This is improper. What are you doing? Mr. Baldwin says, I'm refreshing him. Mr. McClelland says, well, he says he remembers. He doesn't need to be refreshed. So So now we're changing the rules again, right? Because up until right now, Mr. McClelland has taken the position that you have to refresh the person before you can impeach them. Now apparently it's different. We're not doing that. And so Mr. Baldwin directs him to look at the transcript. Mr. McClelland objects again. Is there a question? And at this point, Mr. Baldwin kind of snaps. That's not what you told the court back on March 18th. And he apologized. I'm sorry, Judge. I'm sorry. I didn't think there was any wrong with it. Frankly, I don't think there's anything wrong with, raising your voice sometimes in court to make your point. He wasn't rude. He wasn't assaultive or anything like that. He's angry, and there's nothing wrong with showing that in the course of your questioning. So then he says it again, because the judge, when Mr. McClelland is like, is there a question? The judge is like, I'm not sure. Mr. Baldwin snaps. So he repeats it then in a normal voice. That's not what you told the court back on March 18th. And Mr. Mullen says, I don't remember exactly what I said. So now he gets refreshed and he gets handed his deposition. He's given a specific page and line, but then Mr. Mullen is sitting through there, reading several pages. Kind of looks like maybe he's trying to buy time or just looking desperately for something he can point to as an out. He's pinned. Mr. Baldwin says, you told this court that there was no log, so you didn't know who you interviewed. A little different than what you said today and last week. Yeah, Mr. Mullen agrees with that. It's a little different than what he said today and last week. Mr. Baldwin says, so no log? Mr. Mullen's like, are you asking a question? Yes. He repeats it multiple times. So there's no log. And he says, no, that's not correct. There is a log of interviews we did early on, and it was in the filing cabinet. I said that then, and it was true. And since then, I found it in the file cabinet. This is the example of the defense asking the question they didn't need to ask. You didn't need to ask him to draw the conclusion from it. You were fine sticking with it was a little different than what you said today and last week. Pushed it a little too far and gave him that opportunity to wiggle around. Well, it was true at the time, but then since then we found it and looked at the filing cabinet. And Mr. Baldwin says there is no log of the second set of videos, and there's not. He agrees with that. There's not. And that's not what you testified to last Friday. And he agrees. So he agreed. Inconsistent testimony. Mr. Baldwin asked if Mr. Mullen ever learned that Libby's phone was either no longer in the area or no longer in working condition. There's an objection to this. They have a sidebar, and when they come back, that objection is sustained. Very interested to know what that objection is and the basis for that ruling, because that seems to be pretty straight impeachment of the investigation and his testimony. Then asked if he had heard Mr. Harshman testify about the van, and if he'd heard him say that there was no social media where a white van or van was talked about. He did hear those things. Dr. Walla was on site talking about the case. Yes, he knew that. So it would be important to find out if the van was being discussed to determine if she knew that and was feeding him information. Yes, he agrees. That would be important. When you looked at social media between 2017 and 2022, did you see any? He said no. And then Mr. Baldwin asked, did you even look? And he said no. For a guy that's been very, very nitpicky about the details and the questions, this part of the question is not technically right, so I'll go ahead and answer it no, and then I'll dispute that one specific point. He did not take issue with this when you looked at social media between 2017 and 2022. Didn't point out, I didn't actually look at any. He tries to create the impression I did look and I didn't see any with the way he answers the question this time. But then specifically asked, did you ever look? No, he didn't. Did Harshman? Don't recall. Would it surprise you that there are dozens of things about a white van? This is objected to as speculation, and that is sustained. I don't think would it surprise you is calling for speculation. And then asked, you don't know what Dr. Wallace said to Rick? He said, no, he doesn't. So, picking apart a lot of the stuff about the van. Mr. McLeland then asks, when Richard Allen made the admission about the van, love how he characterizes that, made the admission about the van, it was the first that you had the information about the van. Yes, it was. And then after that, you interviewed Brad Weber about the van. Yes, information we already know. Not really any point in having this cross, but they did anyway. We then had a jury question. While this question is being handed up, I noticed that one of the security guards in the back of the room is dozing. He's nodding off. I noticed this one because you're security. If anybody in this room should be alert, it should be you. But also just in light of that tongue lashing that everybody got from the bench the other week about how, I don't conduct court in your bedroom. I'd appreciate it if you don't sleep in my courtroom. Maybe look to your own. The jury's question was, why would anyone discuss the van prior to Rick Allen's confession that a van scared him? Mr. Mullen says, well, that's the reason we looked into it. It's the first we'd heard. So Mr. Baldwin follows up. Had you heard any other stories or interviews out there involving a white van with blacked out windows and a thin white man offering candy to kids about a half hour from Delphi? That sounds pretty specific. He doesn't recall if he heard that. What about a white van near? There's an objection at this point that is sustained. Ever hear about a white work van being driven by a man named Aaron? Objection beyond the scope of the jury's question. That is sustained. I'm like, okay, the jury is specifically asking for reasons why they might have talked about white vans on social media. He is bringing up what clearly appear to be conversations about vans on social media. Don't see how this is beyond the scope of the question, but in any event, we then have a sidebar. And after the sidebar is concluded, Mr. Baldwin then calls Brad Weber back to the stand. Brad Weber does not really dress for court. He's wearing a plaid flannel shirt and blue jeans and some kind of scuffy looking shoes. Mr. Baldwin starts by saying, you were upset at me last time we spoke. Do you remember why? And Brad said, you were trying to tell me what I did when I got off work. Mr. Baldwin says, you testified you went directly home from work, but that's not what you told officers Poole and Goatee on February 18th of 2017. Mr. Weber is like, well, who are they? He performs much better in his testimony this time. Possibly like got the impression might have had a word put in his ear about, behavior. Maybe try not to lose your temper. He doesn't lose his temper in this one like he did the first time. But he does like stutter and stumble and, reach for his answers quite a bit. So that's not what you told Poole and Goatee on 2/18/17. But who are they? And Mr. Baldwin says they're law enforcement. Oh, but I don't remember talking to them. So Mr. Baldwin hands him the 302 and says, read their report and tell me when you're done. So he does. And Mr. Baldwin says, you told them you went to your ATM machines and gave them routine maintenance. And Mr. Baldwin says, Mr. Weber says, I don't remember that. And Mr. Baldwin says, well, this says so. Mr. McClelland then objects to improper impeachment, and that's sustained. So show him the statement, don't show him the statement. I mean, it just doesn't seem to matter what they're going to do here. It's the rules are going to change depending on what they're trying. So then asked about where he was the weekend before the murders, he said he went on a 3-day trip to Arizona and he had gotten back on Sunday. So then Mr. Baldwin says, we need to talk about your ATM business. So we talk about it. He has ATMs. They are money machines. How do you make money off of them? He makes money off the surcharge. So when people take money out of the machine, they pay a surcharge and he gets that after he pays the business where the machine is. Asked how many he has in 2017, he says, I don't know. And he's like, just continuing to kind of stumble a little bit and says, volunteers, at one time I had 30 something. This day I have maybe 15. Does that help? And Mr. Baldwin says, it does help, but I need to bear down on 2017. So please take a look at your deposition. So he does, and he reports that this says an estimate of 35. How often do you attend them? He says, I don't know the answer. It's on a need basis. If they need money, I put it in. He is then refreshed with his deposition again. And so I guess I don't remember the question. He says, I do something with ATMs every day. I look up on the computer to see where they sit money-wise. I go and put the money in. I put in the receipt tape. I get the cash from the bank. I don't take cash out of the bank. The customer takes it out and pays a surcharge. So if the machine runs out of money, it has a screen that doesn't let it dispense. So he is not making money then. If the receipts run out, that doesn't particularly bother him. So as far as the specific bank that he went to, he said probably Regents, but not sure. This would be the bank that he gets the cash out of. So the example, you take $100 out of the ATM, the bank takes a surcharge and then puts that in my account. Where does he get the cash he puts in? He gets it from the bank. He has to put cash in on a regular basis. These machines are at gas stations, taverns, and restaurants, places that tend to be busiest over the weekend. The geographic area where these ATMs are is in Indiana. Mr. McClelland objects at this point to relevance. The judge says narrow it to that date or it's not relevant. So she wants to get to February 13th or it's not going to be. That's her narrow definition of relevance. We can't draw inferences from the surrounding circumstances, apparently, unless we're the state. So what would necessitate a visit to the ATMs? A lack of cash or paper. And you'd been out of town for 3 days before. Yeah, he agreed. He did not usually use his van to service the ATMs. He would use his black Subaru. The machines are in central Indiana. He's now narrowed the geographic area to central Indiana. Asked how close to the bank in 2017 the machines were. This was objected to as on relevance ground. It was overruled because Mr. Baldwin had specified back in 2017. So Mr. Weber said he went to Regents, but he would go to different branches. And so the closest would be the closest to the machine is the one that he would go to. So he would have to call the bank, usually use the branches in Lafayette. Asked if Guti and Poole ever asked to see his phone records where he called to get cash. He says he didn't remember. He doesn't remember. He doesn't even know who they are. His memory today is that he got off work and he went straight home. He's normally off at 2:30. That day he got off at 2:02, asked to service your machines. He said, no, they're not going to let me off. He just denies it. No. Mr. Baldwin says you got off special that day. And he's saying Subaru doesn't let me off special to service my machines. It was Subaru who decided when I left that day. Then he got a phone call in August telling you to come to the police station. He said no. Oh, he learned a little something from Mullen here because he clarified. I said no because they asked me to come to a different location, not to the police station. I wonder where you got that. So he didn't remember who called him, agreed that it could be Steve Mullen. He'd talked to him before and that it could have been him. But sometimes he gets texts from the investigators. Well, that's interesting. I wonder if those have been turned over. So asked if he would refresh his recollection with his deposition. He says, "Is it up to me?" He's like awkward, is it up to me? Mr. Baldwin's like, yeah, that's actually a fair question. In the deposition, he's refreshed and he says, "It was Steve." He doesn't remember if it was a text or call, but it was probably Steve. And by Steve, he means Steve Mullen. And Mr. Baldwin's like, "You call him Steve." Yeah, he did. And Mr. Baldwin asked, you remember when you had a deposition? And he says, "After you subpoenaed me?" And Mr. Baldwin says, "Yes." So he's asked, "What did you tell Steve?" And he says, "On that day, he took a van to work. He dropped off a trailer, went straight home in 2017. He had both a Subaru and a van to his knowledge. He would only use the van when he was pulling a trailer." Asked if he first told law enforcement he drove a Subaru in 2017. He said, "Probably, but I don't know. My memory is better in 2017 than now." Concedes that. So asked, "What did you do when you get home? Did you take a nap?" "Yeah." "How long?" "Don't know. Probably smoked a cigarette and relaxed, went straight to sleep, then woke up around 5 when somebody knocked on the door." And that was, what did he do after the officer was there? He went back to sleep. That's a lot of sleep for, getting home at 2:30 in the afternoon. Then you sleep till 5. Then you go back to sleep after the cop is there. I will say I'm a power napper myself. I can nap. I'm like one of those people that if it's like under 2 hours is probably. So I don't nap very often because when I do, it's going to be long. But even for me, like more than 2 hours, really, really going to be pushing it. And then once I'm up, like there's no way I'm getting back to sleep for my nap. So I just noticed that as like, that's a really long nap. Really long nap. They told him that the officer told him they were looking for a couple of missing girls and asked about the bridge. Asked if he had ever been on the property on the north side, on the opposite side. He says yes. And he says, "We're here on the north side now, here in the courtroom." So he clarifies, on the opposite side of the creek from your property. Yes, he has been there. Asked if trespassers ever came on his property. Yes. Back in 2017. Yes. Did you ever confront them? Yes. This was a little bit of a setup because it appears there was some prior incident where he had confronted some trespassers on the property. There was a law enforcement response. I've seen the post that the Tippecanoe Sheriff's Office had like a Facebook post out where they said, basically the girls that were missing, have been found. The property owner thought it would be a good idea to close the gate and scare them. So it seemed to me clearly to be this incident that Mr. Baldwin is getting at. Had Mr. Weber denied any of this, he could have either been refreshed with it or potentially impeached with it. So he said yes, and that basically ends it there. You don't get to go any further with it. So that was fairly smart on his part. Would you hear if anyone was screaming on your property? He said, if I was outside, I would. He did not hear any that day. They clarified then that this was not his property. It was his parents' property in 2017, but he did have access to it. Asked about his brother. Didn't answer. He seemed kind of confused. And then we got on this sideline about not being his property, and never quite got back to the brother. But then in 2017, he owned a house in between, I think he said Mossville and Delphi. He also lived in a trailer in 2017. The thing with the brother, I think, got lost because Mr. Baldwin was asking about, who had access to your parents' property in 2017, and he's like, well, you want me to name off every single person who had access to my parents' property? Like there was a lot. I know. So driving on the lane past the Liebert's house, if you were looking to the left, could you see anyone there? And he said, if I was looking, I probably could. This last summer was the last time that he was on the other side of the creek, so he has been there recently. Asked how many outbuildings he has. There are 5. The house is 2 stories. Asked if he gave law enforcement permission to go onto the outbuildings on the 13th. He said yes. I asked to refresh him. There's another objection that, he answered the question. He doesn't need refreshing. Mr. Baldwin says, I'm impeaching him now. And the judge is like, she judge is saying this, I don't know where you're going, in this exasperated tone. I think it's pretty clear. I thought it was pretty clear where they were going, the outbuildings, that we already heard from an officer that he went to Brad Weber's property and asked if he could look around and searched around the property that night, but he did not go into any of the outbuildings. So, refreshed, he said it wasn't on the 13th. Yes, I did give permission. They searched my house, but he didn't give permission on the 13th. So where did he park the vehicles back in 2017? He would park the van over in the grass and the Subaru in the driveway. There's an exhibit now that's introduced, KKK, that looks like his garage back in February of 2017. There were sticks on the ground in the driveway. Couldn't see in this photo. I would have liked to have seen it, but was not able to. There's an objection to relevance that it wasn't the witness hadn't identified when it was taken. This is not a foundational requirement for a photograph. The issue is, does it clearly and accurately depict the circumstances that are at issue, in the time? Doesn't matter who took it either. It's just, is it clear and accurate? So Mr. Baldwin says, he did say, he said it was clear and accurate in February 2017. So then the judge does her own little step in it moment. Well, what do you know when this photo was taken? And Mr. Baldwin says, according to our record, February 19th of 2017. Oh, so yeah, now the jury knows even more. This isn't just like a maybe it's close to when it was in February of 2017. It actually was February 19th, 2017. So photo KKK is now admitted over the objection. Mr. McClellan asked for a sidebar at this point. They have a short sidebar. When they come back, they clarify that the outbuildings that were searched, they were talking about at the Deer Creek house and not the other properties that had been mentioned. And Mr. Weber also clarified that in 2017, there were 3 outbuildings. There are 5 of them now. That was the end of his direct. And he did do much, much better than he did the first time he was on the stand. Mr. McClelland then testified, your memory is much better in 2017 than it is today about what happened in February 2017. He generally agrees with that. Do you remember talking to law enforcement on February 17th, 2017, just a few days after? He says he doesn't know, but they stopped him a couple of times. Asked if he remembered some other specifically named officers whose names I did not get. He says, I don't remember. I got stopped on 625 and they searched my car and my house. Maybe volunteering a little more than, needs to be said, but he says it. So now they know that happened. Then on February 13th, you took a nap. You asked to look around the property. They didn't ask to look in the outbuildings. Later, they did ask, and you let them. And he says, yes, I let them search my house. So after waking up at 5:30, next time he talked to them was at 8 o'clock, and he talked to them pretty much every day for a little bit. Going back to this February 17th, he says, if it's the day I'm thinking about, it's when they stopped me coming home. Asked if it would refresh him to look at the report. He looks at the report. He says, I don't remember this particular guy, but I told them I went straight home after getting off work at 2:02. and then he slept until getting woken up. So it appears that that was his original version of events. He then changed it the following day and now has changed it again back for trial. So don't know that this is super helpful for the state because it's just showing his flexibility with the account, but they clearly seem to want it to suggest that, the first story he gave was the correct one. In 2024, when he got the call or text to come in, do you remember if he got a call or a text? He said calls come through. Calls have difficulty coming through out on the property. They get lost sometimes. So people text because texts come through better. I want to repeat this because I know that there is somebody in particular who is listening to this and has had questions about something that came out in previous testimony. According to Brad Weber, calls will not come through sometimes on the property, but texts come through better. So people will often text. Asked if the officers told him what they wanted to discuss, he said no. Baldwin and then redirect said, you told Poole and Goatee something different. And he says, I think so, according to you. So that's about the best I think that we're going to get from Brad Weber. He thinks so, that he told Poole and Goatee something different. We then had several questions from the jury. Do you know if the ATMs would have photo or video of when you service them? He said not the machines themselves, but some of the places where the machines were located would. How far in advance do you have to order cash for the ATMs? He said, it sounded like he said the problem is coins. These must be a different type of ATM that I'm used to. I'm not used to coins from an ATM, but he does just describe them as money machines. So it could be like a changer, a changer. I don't know. Maybe he's also got a changer. He said at Regents, usually they would have to call a week out. What is the process to clock out at his work? He says when you go through a turnstile, you use a badge and the badge releases the turnstile so you can walk through. I would have liked follow up on this too. Like once you come through and you clock out, how far is it to your car? How big is the parking lot? How far is it to get back onto the highway? We have the Google map, according to Mr. Mullen, that according to the Google map, it's 20 to 25 minutes for the drive. But Google Map isn't going to account for, whatever the process is to be able to get out. Are people leaving at the same time? Is there another gate you have to get through? Like anything like that. I would have liked some follow up on that, but we didn't get it. So just that the badge releases the turnstile. What driveway do you use to access your home? He says the one that goes under the bridge. Mr. Baldwin then follows up that there is another way in. He says, yes, he can get in and out without using the driveway. Do you drive under the high bridge and would you have taken that route on February 13th, 2017? The answer was yes. Do you typically go home from work at Subaru before going to service your ATMs? And he said, typically no, he would not do that. So then there were no other witnesses for today. We had an early conclusion to the evidence. So instead, Mr. Baldwin, the judge said, Mr. Baldwin, you wish to make an offer of proof. So Mr. Baldwin states, we intended to call Kevin Murphy. He was one of the original investigators on the case. He would have said that the entire time he was on the case, he would listen to Unified Command during their morning sessions. They would say that up to 2 to 3 people were likely involved and possibly as many as 5 or 6. That was consistent, and that they never said that only one person did it. Mr. McClelland objected to this because we've heard what other people said, and he says he didn't have contact with Unified Command, so it would be speculative at best. Oops, I just broke off that part of the pen. That seems like a bad objection to me because he said he would listen to the Unified Command during these morning sessions. So he's just reporting what he heard. That's not a speculation problem. Nevertheless, Mr. Baldwin also asked to incorporate his July 31st, that set of hearings testimony into the offer of proof. The judge said that she sustained the cumulative objection. This is not cumulative. There is additional information here, as many as 5 or 6. These are details that did not come out from when Doug Carter was on the stand. These are additional details. This is not cumulative. Nevertheless, that was sustained. Mr. Baldwin then said he also has an offer of proof as to Mr. Holman, to Jerry Holman, related to the third-party suspect. He wanted to ask him a few questions. For example, if Richard Allen had told police, if my spit is found on the girls, but I have a good reason for it, would that be evidence that would be used against him in this trial? He explained the questions were things that he attributed to Brad Holder and Elvis Fields. If those things had been found as to Richard Allen, would law enforcement use them in this trial? Mr. McClellan said, well, this calls for complete speculation. We have that evidence alone. If we have only that evidence, we wouldn't have charged him. And that's why we didn't charge Elvis Fields. Well, they had quite a bit more evidence than that, didn't they? And frankly, they charged Mr. Allen on quite a bit less than that. Another question for Mr. Baldwin, he would have wanted to ask if the state's crime scene photo was found on his computer with showing 2 girls lying on a forest floor with sticks on them. Would those be used in this trial? This is getting to Brad Holder's social media stuff. So it's again with the third party culprit. The judge says something. The judge does a little oopsie here. You have no evidence that connects these people to the crime. There's no DNA. Well, no shit, Judge. There also isn't Rick Allen's DNA. And yet here he is on trial with apparently a sufficient connection to the crime. So what's our standard here? It appears to be a double one, that we can try Mr. Allen without DNA, but to have a direct connection to argue a third-party culprit, we need to have DNA. No evidence that connects these people to the crime. There's no DNA. And then as far as how the evidence is used, how we use the evidence, that's not his job. That's the decision of the prosecuting attorney. And Mr. Baldwin with his final question, also if Mr. Allen had made incriminating statements. He then made a point to say he respectfully disagrees that there's no evidence against them. There's lots of evidence against them. And judge says, no, Mr. Baldwin, there's no nexus. What you don't have is a nexus. And Mr. Baldwin said, we disagree. The court's never explained what it thinks a nexus is, but we've made our record. That was the conclusion of the day. Yeah, the court's never explained what it thinks a nexus is. The law says a nexus is a direct connection to the crime that needs to be more than mere supposition, mere speculation. Can't just be proximity. So we've talked about this many times. My neighbor has a key to my house. I can't say, well, he's got a key to my house. Maybe he's the one that murdered my wife. You would have to show some additional something on the part of your neighbor. Like, I don't know, neighbor's DNA was found on or in my wife. You know, that might maybe get you a little bit closer. That's the DNA link that she's wanting for. But you don't even have to be that strong, you know. Neighbor was caught on surveillance video, creeping around my house, trying to peek in the windows, you know, shortly before my wife was found dead. Yeah, that's going to be enough to get in third-party culprit. That's a nexus. So I tend to sympathize with his perspective on this, that, yeah, it's not clear what she thinks a nexus is and why somebody implicating themselves, somebody posting remarkably coincidental, you know, images to their Facebook that look an awful lot like the crime scene that nobody is supposed to know anything about. Having these connections, you know, with all these people with these odinists that participate in practices that, according to expert testimony, is consistent with the types of things that that odinists do. that those types of practices are reflected in the crime scene, and that another one of these related Odinists, that they're all connected together, borrowed a car this weekend from his sister and brought it back with blood all over it. These things to me seem to establish a pretty clear connection. I mean, certainly at least as to Elvis Fields, who implicated himself. Because, yeah, that puts him on the same footing as Richard Allen. Absent, of course, the part where, Richard Allen is held in solitary confinement for 13 months and, made psychotic. Elvis Fields confesses to his sister like the day after. Confesses to another sister at another time. Then makes this statement to the police, this weird statement to the police. If my spit was found on the girls, but I have an explanation for it, would I still be in trouble? Way more incriminating from my perspective than these confessions that came from Richard Allen while in a psychotic state. But that's clearly just my opinion, and my opinion is not the authoritative one in this case. Should Mr. Allen be convicted, Judge Gold's opinion won't be the authoritative one either. It will be the Court of Appeals' opinion. So we'll just see how all that ultimately plays out. That was it for the day, guys. So let's go ahead and go through some of your questions and comments. Cat Not Williams, I'm behind, but wanted to catch you live to say I appreciate you and your fight for transparency. Well, thank you very much. I appreciate you as well and for being here. Susan Schleppenbach, I feel Abby was drowned to the point of unconsciousness or nearly. Was there anything said about internal autopsy, water in the lungs? The pathologist did describe the process of internal autopsy, that was, standard procedure that was performed. He did not testify to anything about water being found in the lungs. So I can see this also being a viable theory, but without any type of water in the lungs from the autopsy, I don't think it works. Brandon Lynn, I think the fireman's carry solves blood running up the face towards the eyes, nose, blood running horizontally over the leg, one arm up after body laid on ground, no drag marks, etc. Thoughts? Yeah, I mean, I think the farmer's carry, it's going to invert, the body and cause that flow pattern. Here's two problems with that. One, the crime scene expert is only claiming that Libby was moved after she was, initially cut. Abby, he believes, was in the same place the entire time. So there was no fireman's carry of Abby. It would not explain the same kind of reverse flow pattern that was found on Abby's face. The other problem is just sort of the general problem of Richard Allen being a small man and a farmer's carry of a 200-pound woman could be a challenge. A 200-pound girl, that could be a little bit difficult. I will defer to the men who are stronger, than me on that kind of thing. I agree that men can sometimes be ridiculously strong. I guess I'll share the story about, I have at various points in time done like more and less weightlifting, just strength training basically, and try to stay strong. Just helps you with functionality, throughout life and everything. It's one of those things that pretty much makes everything better, being stronger, more athletic, more healthy, all of that. But anyway, so I'd been on this strength program for, I don't know, like 6 months or so, something like that. And I do lots of big compound lifts because I don't really like weightlifting. I don't want to like spend time. I'm not there to I'm not a bodybuilder. I'm not trying to like hit this specific thing or whatever. I'm just functionality. I want to be able to lift big things. So a lot of barbell work, big compound lifts. So I was doing deadlifts. I was feeling pretty proud of myself because, I'd gotten my deadlift up. It's like over my body weight. I'm not quite at 200 pounds with my deadlift, but I forget, I was like 185, something like that. It's nothing remarkable at all, really. But, for me, it was pretty good. And so Jeff, who had not been doing this program with me at all, decides, maybe he'll do it too. Like, it's probably a good idea. So like, okay, let's go ahead and go out and get your baseline, see where you're at. So we go out and Jeff, with like no training whatsoever, just like promptly deadlifts like almost 300 pounds. So I get that I don't necessarily have a great perspective on male strength. That said, getting it up off the ground is a little different from getting it up off the ground and over your shoulder, and then doing the carry. Definitely not saying it's possible. It's just one of those things to kind of factor into consideration. But I think the real problem with this, as far as a total explanation, is that that could explain Libby, but it doesn't explain Abby. Not under the state's theory, anyway. OB Nurse Chelsea, is there any recourse for the defense for Goal not giving proper reasoning? No written opinions or work shown, case references. She just says she knows the case law. Can they request a written opinion? Thanks for all you do. Well, they can request it as much as they want, but she doesn't have any obligation to provide them with one. And I've theorized before. This is a similar thing that I saw with Judge Goal or with Judge Bev. I finally get to say Judge Bev, and it's right over there in the Karen Reed trial. That often she would make these rulings without really stating the basis for why she was making that ruling. And what I pointed out was that and part of the issue was that her instructions to the parties during the trial was that they were to simply say object. They were not to state the basis for their objection, and she would then rule on it based on presumably whatever she thought the objection was or should have been. And so this was very clever, because what it does is it serves to kind of insulate it a little bit from appellate review, because if they don't know your actual basis, then they can essentially consider whether there is any basis that would justify affirming your decision. There's this general principle of appellate review that they can affirm on any basis that the record will support. So if she pins herself down to reasoning, that's something they can point to when she misunderstands the law, or she misapplies it or something like that. They can point to that and establish error. And so an error in legal reasoning, that is grounds to say that's an abuse of discretion, like you didn't apply the correct standard. So it's a thing that judges who are hesitant for review by higher courts, it's a pattern that they can develop. They just simply don't give you a reason, because then they can't be pinned down on it and found to be incorrect. And they get the benefit of this premise that, as long as there's any basis that would justify the ruling that they made, then it's okay. It's going to be affirmed. So that is my suspicion as to what she is up to. She has been reversed, more than once. So you get bitten a few times, and they learn. Brandon McRoby, he just handed you your entire ass. Words of wisdom by Andrea Burkhart. Mic drop. I mean, I'm just telling you that would happen. That's what happened. I mean, this was a full on, Morgan Tremaine, 15 minutes of fame. I could say the same thing about you representing Amber Heard. This was that moment. You didn't play those other incel videos. Yeah. And neither did you, as far as I noticed. I mean, call him out, put him on the spot. Is he going to now come in and show up in his rebuttal case and show us some random day in December where Rick's just sitting in his cell doing nothing, fiddling with his tab, pacing, twiddling his thumbs, maybe. It was good. It was a great moment. Applejam PB, if you ever visit Maine, we have China, Sweden, Mexico, Norway, Egypt, Poland, Denmark, Peru, and more. There's a poem about all the countries. No kidding. Why is that? I'm very curious to know why this is. I mean, I noticed it obviously with Delphi. Here I am in Delphi. Delphi is, I have a hard time even saying Delphi sometimes, because it's Delphi, Greece. The home of the Oracle of Delphi, the Pythia. Had all of these very famous prophecies. Probably most famous one is the one to the parents of Odysseus, that they would have a son that would grow up to kill his father and marry his mother. So out of fear, they abandoned their son on the mountaintop, but he ends up being rescued and saved by another kingdom, and then raised to adulthood, and ends up coming over in war and battles the original kingdom, and kills the father and marries the mother. And there's several of them. There was an oracle about Socrates, asked who the wisest person alive is. And they said Socrates, and Socrates, thought that was pretty wild, but he said the reason why is because, he knew what he did not know. that's what made him wise. It's I took ancient Greek in college, and I read some of these old texts, including the apology that one is in. And so that's the last little bit of Greek that I still remember. It's un uk oida uda oyamai. That which I do not know, I do not think I know. But I always wondered about that. Like, how did this place end up Delphi? Like, what's the connection? Who thought of that? Like, what was there? I just always wanted to know. And I'm curious too about these other places. Like, why do you name cities after foreign countries? I'm just curious. A Sparky 2, please buy Truth Seeker a meal of food. Thank you for what you are doing. I will buy her more than a meal of food. I will buy her like many meals of food. I will buy her like, I will buy out the restaurant. I will buy her drinks all night. Like, I will buy Truth Seeker. Yeah, I owe Truth Seeker a lot. She really, really saved us today. She has been an enormous help with managing the line, helping when we need folks who are local, because she is local and has some local connections. When they need to get folks on short notice, hey, show up and hold a spot until like the regular line sitter gets there, things like that. She has really been on the ball with that. So that was very awesome, and I will definitely buy her something super nice. Keminoke, didn't Rick say he wouldn't cross the bridge, and now his daughter says she crossed it with him a few times? Probably why Juror asked that. Let me check. That would have been in his interrogation video. I don't remember for sure. Okay, that would have been day 9. Day 9, we had Mullen. Okay, maybe it was not. Yeah, no, it wasn't. So that was just when Mr. Mullen was first on the stand, and they had not yet opened the door. It was only after Holman testified that we got to see the interviews. So I think that was on day 11. Just trying to keep track of all my notes here. No, okay, there it is. Sorry about that. It was day 13. Day 13, we had all that foundation that we had to get through before we did it. Okay. Monday, February 13th. Usually walk down to the bridge. When they spend time down on the trails, walk down to the high bridge, stopped a little way, looked for the fish. Talking about the parking areas, looking at the map, which way would you travel there? Ever occasion where you might have gone another way. I think there's a way you can go past the farm entrance, or you can wind around. I only found it out by accident. But no, if we were going to go there, we'd go down through town, contrary to what Mr. Mullen said he said. Went to the sheriff's office, saw the girls. Stop parking there with a no parking sign. They walked there. There were trails they didn't know were there. But he had gotten involved with Dan McCain, I believe, with the canal. Something about the Erie Canal Foundation. Sat there a little bit. Used to be a tiny one-way bridge. No, he says, I've been across the high bridge back when it was in better shape. But just this time just went out to the first one and looked for fish. So no, he says back around 2026 to 2010 or something, he says he's been across the high bridge back when it was in better shape. So nope, he did not say he has not been there. He did say he's crossed. But it is possible that the jury had some questions about that. Definitely can't rule that out. Stephanie, I'm behind a donation towards Sharpie pens. Thank you. I might indeed. Actually, somebody, I've been getting these wonderful gifts. People have been so kind and so generous. They've made me these lovely gift bags with different things. Oksana gave me some teas, which I really appreciated because, I'm not necessarily a super coffee person, but you get what you're used to. And I'm kind of a tea snob. I'm used to like my teas that I like. And she got me sencha green tea, like a nice sencha green tea bag. It's like my favorite Indian. It's like a Japanese green tea. It's wonderful. So thank you so much for that, Oksana. But other folks have given me little gifts today. In fact, I just walked up today and I was given a gift of a packet of notepads. So everyone is taking care of me, making sure I have everything that I need. But yeah, somebody else gave me a little pack of these Sharpie S gel pens. They really are fabulous. I really might have a new favorite. So even when this one runs out, it looks like I got 2 more freshies waiting for me. So thank you for that. I will take full advantage of it. Sandy D, thank you, Andrea, for showing what it truly means to keep the scales balanced while held high, to see clearly while blindfolded, and to fight fairly while armed with a sword. You inspire us all to do better. Peace sign. Well, thank you for that. I try to be very clear about what my lens is. I saw a wonderful comment the other night that I really appreciated, and it said, you see what your lens is, but you have the ability to see through others. And that I think means a lot to me. That is a sign, like they tell you, that's the sign of a good lawyer. If you can only see through one perspective, you're not going to be a good lawyer, because you're not going to be able to speak to everybody who might be, who might be looking at your case, who might be sitting on your jury. You got to be able to put yourself in other people's shoes and see things from their side. So I do try to do that. I feel like I've tried to do that in this case. Obviously, I have my own thought process about where I think the facts have led us, and I've shared, my thought process and how it's gotten me to where I'm at with what I think about this case. But as I say over and over again, I'm not definitive. I'm just one person. These are my opinions, and that part of it you can take as much value or as little as you want. My primary goal here is really to share the facts with you, since we do have such a limited record, limited ability to rely on information from the media, as I think we have seen yet again today. Understand there was a whole blow up about the media's reporting that Brittany said no, she did not love her father. Yeah, that's absolutely not what happened. That she was being all distant from her family and wouldn't look at Rick in the eye. Absolutely not what happened. Not what happened. She looked Rick right in the eye after she said she loved him. She's got a smile on her face. She has love in her eyes. She sits with her family after her testimony is done. This is all just, this is just smear stuff. It really is. And how low to go after these people who have done nothing wrong. Whatever you think of Rick Allen and whether you think he's guilty or not, his family has done nothing wrong. So they are suffering through all of this. And They don't get any recognition or sympathy for that, you know. So I think that's a pretty low angle to be taking, but in any event, it is not true. That is not what happened in court today. Gov.audits. I pray Goal gets the ultimate smackdown. The public's right of access to information is coextensive with that of the press. Hutchins versus KQED Inc. 438 US at 16. Nice citations. Yeah, there's several cases to that effect. I think I cited some of them in my own memo, but a lot of Supreme Court authority that the press is not special. They don't have any more rights than we do. This got really fleshed out in the context of reporters' privilege, right? This idea that reporters don't have to answer subpoenas to turn over their sources. They argued that this was grounded in the First Amendment. The U.S. Supreme Court says, no, you're no different from everybody else, and everybody else has to honor government process and subpoenas to provide information that's in their possession. So you do not have a First Amendment right to not disclose your sources. So there are several states that have adopted statutes that create reporter shields, varying degrees of protection. Happen to be aware, most familiar right now with California's is very strict. Like there's pretty much no way you get information from a reporter. Very, very narrow exception for if it's necessary to like prosecute somebody for a crime and there's no other source of the information, that type of thing. Other places, you know, maybe more, maybe less. But those are all statutory. Those are not First Amendment basis. And it's specifically because the First Amendment has been held not to give the press any greater rights than the public as a whole would have. Lisa Shelton, I think I put some of those pins in your care package. Yes, you did, Lisa. It was you. And thank you so much. If not, Lawyer Lee got 2 sets. So ask her. And I agree. I was very upset with the pin selection in that town. It was not ideal. You know, it was not, I mean, they did have, you know, these pins that I got. I've never seen these pins before. These Basic pins or whatever they are, these ones that I bought. And they're fine. You know, they work all right. They're not as good as my uni balls, but I haven't hated them. They do have just that slightest little bit of the scratching that like makes the hair on the back of my neck stand up. But yeah, I'm these Sharpie gels. These are where it's at. So thank you very much for that, Lisa. I'm going to really appreciate having those. Mendy, line sitter recruiter here. Shifts open from 9 a.m. to 1:30 p.m. for inside the courthouse. Use the link in the chat to send a message. I haven't updated the sign up yet because I'm sitting in line. So yeah, guys, this was the chaos became very clear in court today. I've heard, you know, rumors about what's going on in the goal and so forth. I don't know about any of that. But yes, there was a very, very large crowd down there waiting at lunch. It apparently started to gather around 11 o'clock. And so it does appear that now we run the risk of losing our spot after lunch if we don't have somebody that's down there holding it for us. So if that is something you are able and willing to do, it would be certainly so appreciated, both myself and Lawyer Lee, looking for help to make sure that, you know, the folks who are sitting out all night in the rain for us are not doing so in vain, since they can't assure us the entire day in court. Anything you can do to help with that would be very, very appreciated. Jennifer Ferguson, evil triumphs when good men do nothing. Thank you for being one of the good ones. Well, that's a very kind thing to say. I do love that saying. Because yeah, that explains a lot. It explains a lot of just how things happen in the world. I know on the internet, you're not ever supposed to talk about the Nazis, you know, you can't ever go Nazi. But there's a lot of that involved as well. You know, of course, I was a philosophy major. So of course I read on the Banality of Evil by Hannah Arendt, Eichmann in Jerusalem. It was a series of pieces that she wrote as a Jewish woman who had fled Germany in the early 1930s before, like as Hitler was, you know, he'd come to power and as things were starting to look fairly bad. She had been sort of obsessed with Eichmann and capturing him because they had to, hunt him down after trial. They'd done the Nuremberg trials for like all these other people, but Eichmann had escaped. So he was found later in Argentina, I think, maybe Brazil, somewhere down in South America, brought back for trial. And she attended that trial as a correspondent. And so she wrote this book that was kind of her like awakening about the nature of evil that she got from watching this trial, because Eichmann to her had been the epitome of evil. He was the brainstormer of the final solution. And she's got a lot to say. I mean, she's got a lot to say and a lot of nuance to it. And I hate to do her, so little justice by summarizing it like this, but I'm going to, because it's a live stream in a short time. And I, not like I read it before I'm saying this, but like reread it. But ultimately, she's talking about the bureaucracy and the machine, and how just how easy it is for things like this, for people to just kind of go along because that's what the system is and that's what's normal, and that evil can bloom out of just these very banal, processes and laws, and everybody kind of just doing their job. Everybody's just doing their job. So I think there is a lot to that, that it creates a vacuum when people don't step up, and that just creates room for even if it's not evil initially, it creates room for bad things to grow to the point where they can become evil. Clinton Hall, loved the Kathy Newman, Jordan Peterson reference, instantly captured the tone and dynamic of the questioning. You do an amazing job painting the courtroom scene with your words. I mean, it really was. So you're saying, so, I mean, she was using that so, and then characterizing it. And that's what made me like, this is totally Kathy Newman right here. Like could be cloned. So best example I could think of to depict how that was going. Thanks so much for that compliment. Glad that visual worked for you. Holly Clay, was the jury still in there? I'm not sure at what point this is referring to. Unfortunately, I didn't see this when it came up. Sorry, I can't answer. I don't know what point we're talking about. Laura, how are you interpreting the juror questions re Mr. Allen's mental health? It makes me think that they are considering the confessions as legitimate. I thought that they just had a lot of curiosity about the confessions, and I mean, you can look at them as, are they thinking about the confessions as legitimate? You can look at them as, are they steel manning, the confessions, like the state's position on the confessions. I didn't really see them as really like necessarily leaning one way or the other. I think there is, this potential discordance between, seems to be able to act in his own self-interest as far as leaving his cell, but so then how does that translate into faking symptoms? Something to bear in mind too is that the jurors are sometimes asking their questions, like they're writing their questions down before the testimony is concluded. So some of these could have been written down like while they're in process. Just one more thing to think about. This one in particular, I have a sense that there is a specific juror that is asking what are almost rhetorical questions. Like these are not necessarily, I don't get the impression these are necessarily calling for a serious answer. And the questions that these ones reminded me about, like, does somebody having depression and anxiety as a child mean they're going to be a murderer or a sex addict? These don't really seem like you need an answer to that. It's more that we're making a point by asking the question. And the similar impression I had got before was when Mr. Mullen was on the stand, and pretty sure it was Mr. Mullen. And the question was whether how many vans go down Brad Weber's driveway? Do you know how many vans go down 625? Like these don't necessarily seem like, he probably doesn't. And so are you really asking for an answer, or are you asking to just sort of make the point to somebody, just make the point that this question is asked and doesn't really need an answer. Did you watch the October 2022 statement to police? That seemed to me to just be kind of background information, because we've seen it. And so we've seen that kind of for his baseline, and we formed our own impressions about how he presents based on that baseline. And so I could see the jury wanting to know if she's seen that, because that's where we're starting from. And so, no, the fact that she's not, and she started from a baseline where he's already incarcerated, he's already, under stress, he's already adjusting to this environment and these conditions and everything. Does that make her opinion more or less valid? I mean, it seems like it maybe makes it more a little bit, because it isn't skewed as far as ours would probably be if we were in that same position, having seen him make that statement, seeing how he functioned under that kind of circumstance. Now, question could be, because he did seem calm and he did stand up for himself, he didn't crumble and turn into a little wallflower. Maybe the whole he prefers to avoid conflict is maybe not so consistent with walking out and calling, saying, Mr. Mullins, I think you're an asshole. So I could see that take on it. Maybe it would have been better if she had watched it under that kind of framework. So that's a possible way to look at it. I can definitely see that. So then, distinguishing between major depressive disorder with psychotic features versus a psychotic disorder, this struck me as potentially one of the knowledgeable juror types of questions, because if you don't know about psychology and these disorders, I don't know that you're going to necessarily know that there could be a distinction between those things. That these could be considered like separate sorts of categories of things. So to me, it sounded like a point of clarification from somebody who has some information, some knowledge already, some pre-existing knowledge about mental illness. And so distinguishing between, what does that mean as far as what's the difference between them? Can objective testing be interpreted in multiple ways? This also seems like it has the possibility of being a do we really need the answer kind of question, because if it's objective, then it shouldn't be subject to the interpretation of the person who is reading it. It should be consistent. It should be replicable. That's what objective measures are for. But it could have also just been an inquiry, I think most people would agree that relative to like physics and chemistry and things like that, psychology is a relatively soft science. And so what counts as, objective in psychology, maybe not so hard as something like chemistry. Questions about objective testing prior to incarceration. This just seemed like a basis of her information, just kind of wanting to know more about what she had for then, and the difference between delusions and delirium. These are just concepts that the jury has heard. So, I mean, I can see how you might look at these questions as skeptical of the witness. But my impression is just that that's been fairly consistent for most of the witnesses. It hasn't been like they've been uniformly agreeable with the state's witnesses and uniformly skeptical of the defenses or anything like that. They just seem to be very inquisitive. Apart from that one that, like I said, it seems like this might be the same person who's like just asking the question to make the point in the asking. But I don't know. I'm curious what you guys think about that. If you're getting any kind of like bias or lean or something like that from these questions, some of them I feel like I have, but these ones I didn't necessarily get that. They just seemed like pretty fair inquiries, just things that are going to be information for the jurors to think about. Donna Brack, why was semen in cervix not tested? Because they could not do both as a confirmatory test for the presence of semen and a DNA test. She indicated you had to choose one or the other. And given the importance of that particular, bit of evidence, if there were DNA in it, that would have been extremely important. And so they made the choice to do the DNA test. And they located the presence of no male DNA. So that was why that choice was made. I'll do it when pigs fly. Did the autopsy show what was in their stomachs? Not that we heard any testimony about. Not that we heard any testimony about. John Doe, did the girls get post-mortem pregnancy tests? Not that we heard any testimony about. Bobcat Red, thanks to the line sitters who've been sacrificing their time to let Andrea and lawyer Lee get in the courtroom every day. Amen to this. Thank you so much to the line sitters. I really like if everybody is still around. The problem is a lot of people have come and gone. Like I was really hoping that we could do like a big group dinner or something like that, just go out, have a good time. Obviously, all on me. If anybody is still around when this trial is wrapped up, I would absolutely love to do that when we don't need to have people out waiting in the line anymore. I really am grateful, and I want to have a way to be able to thank everybody for the sacrifices that they've made. I spent some time sleeping out there myself. I know that it's not particularly fun, so I'm just very grateful for them taking that on. Holly Clay, you're amazing. Treat yourself to dinner. Thank you for all you do and the time you put into all of this for us. Well, thank you so much. I will enjoy that very much. Holly, Mystery Pin Man knew your name. Is he a follower? I mean, he knew my name. He definitely knew my name. And it seems like he might have known that like the pins were a thing, right? He knows I've got my special pin. So whoever the mystery guy was, either somebody told him, maybe he's watching. I don't know. But thank you so much for this pin. It really was great. Donna Brack. Andrea, have you ever tried martial arts? Women have an advantage on men because of our hips. If you mean martial arts as in like judo, for example, no. I haven't done any type of grappling sport. I box. I use my hands. That's it. We definitely do not have an advantage in boxing because the wide hips are not an advantage in terms of both just rotation and power recruitment, and then also center of mass. Just the ability to, you get your power and your punching through rotation, and it's not an advantage when we are wider in that movement than the narrower men who can do it quicker and generate more force that way. I would totally believe it for things like judo, like you're doing throws and stuff like that. Yeah, I could buy that. I could even see it potentially with things like, like Brazilian jiu-jitsu, where you have a lot of these, you like hold people with your legs. I don't know what to call it. Like I know Brazilian jiu-jitsu when I see it, but I don't know the names of the moves or things like that. But like they get really grippy with their legs, whatever that's called. I could see female hips being advantageous for that. The strength is generally where women do not have an advantage, and that is it's not completely universal, but it is very close. The outliers among women are still not as strong as the average men. So that's just biology. Starlight Selenite, so much gratitude for your Andrea. Your coverage of the trial is stellar. Thank you so much for that. I appreciate it. Oh, Susanna, in his admission, RA said he thinks he dropped a bullet on the bridge, but a bullet was found by the girls. Has anyone brought up the discrepancy? Yeah, that one has come up a couple times. It came up with I can't remember if it was Dr. Walla or if it was somebody that I believe Mr. Baldwin was cross-examining. I think it might have been Dr. Walla about how the details of the confession weren't true. It might have been Mr. Rosie cross-examining Brian Hirschman. But yes, that did come up. And so I had that in mind today when Dr. Westcott was testifying about his confessions were, to facts that were not reality. And that was just, that was a good example of one. Like, this is probably not reality because that's not how it happened. So, I mean, if nothing else, we know this detail is wrong. Lucky Sarita, I've wondered about Libby's phone getting waterlogged crossing the creek, and perhaps this explains the period of time that it was off. Thoughts? I think that's possible, except the issue is that it was still receiving pings. It was receiving pings up until 5:44 p.m., and that's when it stopped receiving pings. So we have like these different points in the timeline with the phone. The 2:32 is when the phone stopped moving. It stopped registering movement. And so that's the state's timeline for basically when the girls were killed or unconscious or, no longer moved, because the phone never moved again after that, they say. But yeah, the pinging, it was continuing to receive texts and calls until, I want to say, like 4 or something. It was pinging until like 5:44, something like that. So that would not be consistent with the phone being off at that point in time. And if it then like goes dark after 5:44, the girls are supposed to already be dead. It can't explain, being waterlogged, that part of the timeline. It can't be reconciled with how that played out. So it is still a mystery. To me, I wonder, the example, obviously the defense's theory is that it's because the phones were, taken out of the area. And that does seem like a possible explanation. I definitely hold open the question about the tower issues. That was a question that the jury had. Did you ever check to Mr. Mullen, check to see if there were issues with towers in this area? No, he didn't. That seems like a really obvious thing to check to me, because that seems like an obvious rule out for why the phones were behaving in this way. That has nothing to do with the phones. It has to do with the tower. And especially now, if we're hearing from Brad Weber that the cell service acts weird out there, then that seems like maybe a thing that you would follow up on as far as the tower goes. One of the ways in an area that doesn't have dense cell coverage, where you have one tower that covers a large area and you don't have a lot of overlapping areas, traffic can affect the cell tower. And so you have a bunch of people out here in this area, and if they are all using the cell traffic, because they're texting each other, they're using data to like get maps, or all the different things that they might be doing through the towers. The tower has limited ability to service the phones to it, and so what that can do is that can kick the phones, some of the phones, over to another tower. What I don't know is, I assume if you have limited capacity and some of the phones have to be kicked and there's no other tower, does that mean they just get kicked off the network entirely? It seems possible, but I don't know. I wasn't given that answer, because the search, if that seems like a possible explanation to me. All these searchers are there using the cell service. I don't know that we'll know that. So don't think we have a great explanation still for Libby's phone, and even the state's expert, Officer Trooper Cecil, he doesn't know. It's weird. Doesn't have any explanation for it. Well, that's not really very helpful. I mean, for us to understand what happened out there, that's a piece of information that seems pretty critical. And so not following up on the towers and the tower functionality, to me, that just seems like a massive oversight. Just one more piece of the investigation that why on earth would you not check this out? Because I'm not even an expert, and that seems pretty obvious to me as something that you would look into. Sarah S., is it weird there were no character witnesses to speak to changes in Richard Allen's behavior after the crime before his arrest? Also, what mascara do you use? So character witnesses typically are not admissible in a criminal trial. You generally can't present evidence of character. Now they could potentially testify to like observations before and after, but the problem is that the state is gonna object to that, be like, they didn't see him 24/7 and blah blah blah. So you're kind of left with Kathy, the one who's closest to him and her observations, and they may or may not want to put Kathy on the stand. So as far as my mascara goes, I use all different kinds. The one I'm using right now is a Milani. The one I used before was Kat Von D. I really liked that one. It was go big, go bold or go home. I like because I like go big or go home. It's like a, it's like a saying. I like it. I like it. It's up there with like put up or shut up time. Go big or go home. But this one that I'm wearing right now currently is Milani. Suyan, talk about allegedly Rick being scared because of a van and still managed to keep calm and have time enough to dress Abby with Libby clothes. I know. The timeline and just the theory of it doesn't seem to make sense. It doesn't seem to make sense to me that you would start from the place where you aren't seen, where you are probably the least exposed, tucked up underneath a steep bank underneath the road, as we've heard it described. And you would abandon that place of safety to go out into the river where now you can be seen from all directions in the middle of the day on a nice day when people are out here at this park and there's cars all over. That doesn't seem like a very not a thing a person would do if they're scared. It's scared of you're getting caught and you run out into the open. That just doesn't make sense to me. But yeah, then the whole time frame of it. If Abby's clothes were wet because she wore them into the river, it doesn't explain why the clothes were found over on the other side of the creek. So you were in a hurry and you ran, but you took the clothes with you, but then you dropped them in the creek over on the other side. I don't know why we even needed to go to the other side. If it's, I'm scared, I'm going to kill the girls, why wouldn't you just do it right there? And then the whole issue with the putting the few branches on them that don't cover them at all when there's all these leaves around, the concealment theory, I just, no. It's preposterous, frankly. It just is. It doesn't cover them at all. And you got all these leaves there. You want to cover them, you make them into a leaf pile. And then, yes, they're going to be very, very difficult to find. Yeah, the whole theory of it does not make a lot of sense to me. Spirit in the Night is a new member. Welcome to the channel. Thank you for that. Freckle Joy, thank you for taking time out of your life to do this for us. Well, it's my pleasure. It really is. This is something, I mean, like I've said before, this is kind of a test case for me, this whole experience of going and reporting out of the courtroom and bringing the facts in a case where there isn't transparency. We don't have the courtrooms, or we don't have the cameras in the courtroom. We don't have the audio. Because it is something that I've considered doing. A lot of stuff that doesn't get reported in federal court. California is notoriously hostile to cameras ever since, OJ, and they all kind of embarrassed themselves with that. Then they did it again for Michael Jackson, and then the press, beclowned itself with that one. I guess they did have the Menendez brothers trial. It's just very rare. They don't do it very often. So different places, just different degrees of accessibility to the information about what's going on inside the courtroom. And this really was a test run, and it's meant a lot to me to see how much people value just the way that I kind of do it. This is just naturally how I am inclined to handle this situation where I'm not normally the fact reporter. So I'm learning, and I'm just trying to be as detailed as I possibly can, and make that most of my focus, but also not be afraid to continue to do what I normally do in my channel, which is share with you my perspective as an attorney and how what I know about the workings behind the scene, the legal stuff behind the scene, the maneuverings and so forth, to just help give you better insight into what is happening inside a courtroom and a trial process. So it has meant a lot to me that so many people have appreciated that, and it encourages me very much to consider keeping on doing it in the future. Steele, can you expand on the spit detail and the social media posts you mentioned that Weber posted? So these were not Weber. These are going to the spit detail was the offer of proof that related to Elvis Fields, because this was a statement that Elvis Fields made at the end of his police interview, where he said, if my spit was found on the girls, but I could explain it, would I have a problem? Basically, I don't know if that's verbatim, but it's something very close to that. Pretty peculiar and incriminating statement to make. And pretty much any other case that I can think of, people would be looking at that statement. Prosecutors and law enforcement would be looking at that statement as that's extremely incriminating. It seems to me to be far more incriminating than Rick Allen saying what kind of good guy would kill two girls. When you have a guy that is telling you you're a good guy, but also telling you killed two girls, that seems pretty logical to me. This is incriminating. So that's the context for that offer of proof that Mr. Baldwin was making. The social media posts, this was from Brad Holder. Brad Holder has posted a few kind of alarming things on social media, and one of them was a photograph that was two girls appearing to be dead on the ground with sticks on them. It's not the crime scene. It's not the crime scene. It's not the girls. It's presumably, actors, girls that are acting. Like, this is an art photo. It's not, it's not a documentary, I don't think. But it's just so remarkably on the nose for a crime scene that nobody was supposed to know, what it was. And, yeah, kind of alarming. Quite a coincidence, while we're talking about coincidences and everything, that one is quite one. Yeah, could be just a coincidence. But it does seem to suggest to me that if, because Brad Holder is an Odinist, does services and stuff like that. And so if this is, Odinist type of stuff, then it seems like the crime scene, if it is not in fact Odinist, it's at least trying to look like it, because the resemblances between these are just really compelling. So once again, I'm pretty sure these are somewhere in one of the Frank's memos. You can see copies of these social media postings. I can't remember offhand which one they are. But yeah, they're quite alarming. But yeah, those don't have anything to do with Brad Weber. I do want to be clear about that. Oh, and by the way, while I'm being clear about things, I do want to correct something that I have said in the past, because when we had the DOC officers testifying, there was one of them, his name, I believe, was Michael Roberts. And I thought that he might have been one of the guards that had the Odin patch, that was reported to be wearing an Odin patch in Westville while guarding Richard Allen. There were two of them that were reported in the Frank's memos. So I thought that it was Michael Roberts. I finally, over this weekend, had time to get back into the Frank's memo and check, and it is not. I want to be clear, it is not him. The names that were named were Robinson and Jones. So I just got Roberts and Robinson, didn't it was very close. And so it triggered that memory, but it's not the right guy. So let's clear that up. Majesta Alexander, could Elvis and others have done this to try to impress Brad Holder versus Brad Holder being directly involved? Maybe. Yeah, I wouldn't rule that out. Freckle Joy, this one is just to piss off the haters, lol. Well, you can't spend too much time and attention and energy on the haters. There's always going to be haters. And honestly, being a hater just says more about the hater than the hatee. That's how you want to live. Go knock yourself out. Sounds pretty miserable to me. But, everyone's different. Sister Golden Hair. Oh, I love your name. That's like a great song. Really like that song. The super sticker. Thank you so much for that. Jessica, both New York and Texas stream their forensic commission meetings on YouTube. Check out the recent meetings in Texas where they discuss a recent discovery about DNA contamination from Sharpies. Oh, that's interesting. I will check that out. I will make my little note. DNA contam from Sharpies, Texas Forensic Commission. I would totally buy that. I'm curious if it's people wearing gloves and then using their Sharpies. I'm going to have to go look now. It just makes me cringe every single time we're sitting there in the courtroom. They put those gloves on and then they grab their pen or they grab those scissors or the things that, 10 other people have already touched. I'm like, why are we bothering with the theater here? I don't know. That Mickey, is court closed tomorrow for voting? It is not. They are continuing to have court tomorrow. I understand it is a state holiday, but that is not getting in the way of this process. So we will be back tomorrow. Suyan, your description of Rick's interrogation twisted my mind. It was so well explained and detailed that sometimes I think I saw the video. Thank you for everything. Well, thank you for that. It was really, it was from what you kind of expect. What you would expect somebody who would commit murders like this, to look like and behave like. I know that that's not always valid. People can fly under the radar. Ted Bundy, certainly flew under the radar, at least in the sense that he was able to be charming. I always found a bit of a creep factor to him. But I totally acknowledge, people can fly under the radar. Nevertheless, you have some expectations about what somebody like that is going to be like. And it's just hard to express how completely not that Mr. Allen presented as. He just did not present as that at all. He presented as a perfectly normal guy, getting more and more frustrated because he's got this asshole that's trying to tell him he did stuff he didn't do and isn't listening to him explain it. People in court, Line Sitter Food Fund. Thank you for all you're doing to help Andrea get the facts out to all of us and restoring my faith in humanity a little. Thank you for that. And yes, thank you to the line sitters so much. The best I could do today was I did leave my umbrella just in case one of the line sitters needs it. It is not looking like it will be pleasant out there. I don't need the umbrella overnight. I have, my jacket, my rain jacket I can wear in the morning with my hood. So hopefully if any of them need it, that will be taken care of. Hans Hop, Andrea, thank you for your work. You mentioned not having an ice scraper on Saturday. In a pinch, you can use a couple of old gift cards from your wallet as a makeshift scraper. Works great. Hey, that's a great idea. I never thought about that. Yeah, I will totally try that. Hopefully it doesn't freeze again. Keeping my fingers crossed. It's very, very warm when the rain comes in. Like this morning, it was reading something like 67 degrees with the rain. So really not unpleasant at all, but it has really been back and forth a lot. Steve Trammell, does Dee have a false confession expert coming? I don't know if we are getting an expert on false confession beyond what we already got today from Dr. Westcott. I'm not sure if she was supposed to be the person on false confession as well. So I'm not sure. I think it's possible that she is who we're going to get. and just talked about the stress, the stress of the situation, combined with his condition, brought him into psychosis. I think that might be all that we're going to get, but I don't know. I really don't. I have a hard time given what Judge Gold's limits on relevance have been, that they would allow in an expert to testify generally about false confessions and the circumstances that produce them. And I also have a hard time thinking that they would allow an expert to testify that he did, in fact, falsely confess. It's getting a little bit too close to commenting on the guilt of the witness. Now, of course, it hasn't stopped the state from eliciting all these opinions about, who's lying and whose voice is whose and stuff like that. But we know it's not the same standard. So I'm not sure if they're going to get any more than what we got today. Glenn F. State theory is that RA was interrupted 15 minutes in and opted to red rum them, but yet he stays on scene an hour and 20 minutes longer to be seen by their witness who they say saw him. Yeah. Yeah, that is what they say. I don't understand the explanation for staying on the scene. I mean, I guess he said he made sure that they were dead. I don't know how long that takes. Can't have taken that long. I mean, if you saw these cuts. Testimony was they would have been unconscious and then died after that, and somewhere in the ballpark of 10 to 20 minutes. So I don't know why it would take over an hour. I mean, I'm kind of with you on that. Don't think it would take that long to move the branches. Still not explained. Abby's clean hands, clean torso. Everything is so clean except for just right at her throat and what's flowing up into her like over her chin. And then like the back of her neck and stuff. That's not explained. Why did we need to move Abby? Well, she's more concealed from the creek, but apparently she's not as concealed from the high ground. Why not just shoot them? I mean, this is an awful thing to say. I realize, I understand, but he's got a gun. Why would you not just shoot them? I mean, with the knife, there's the risk that they're going to scream. You didn't cut their trachea. There's the risk that it's going to take long. It's going to get messy. You're going to get your DNA on them, or you're going to get their blood on you. And then that's going to be how you get caught. Richard Allen watches Dateline. He knows that stuff. Why would you not just shoot them? I got to tell you, gunshots are not extraordinary out here in this area. Like, I don't know that that's necessarily going to draw any more attention. But even if it did, okay, that's going to draw attention. You're in a pretty isolated area, in a pretty inaccessible area. Like you're far away from the trails. Seems to me like you're going to still be able to get up to the road and go back that way. Although, of course, why we're going back to the road in front of everybody driving by, I don't know that either. Just so much of this is really, it just really doesn't add up. So, Just Jen, what basis did Gold deny the Zoom testimony? Well, we'd all like to know, because all she said is, I don't find good cause. That's all she said. I don't find good cause. Normally, having unavoidable scheduling conflicts and or a medical condition are a good cause. So this is just sort of like, we don't know what a nexus is to Judge Gold. We don't know what good cause is to testify remotely. especially when Mr. McLeland didn't even object to that. He was like, well, I don't think they should be, the impeachment hasn't been proper anyway. We shouldn't have been allowed to do that. But if it's going to happen, as she had already ruled it was going to happen, then I don't have any problem with it being remote. So it's not like he's saying, I won't have a full and fair opportunity to cross-examine him. I need him to be here, for whatever reason. We don't know. She just said, I don't find good cause. Her issue with it seemed to have been impeachment, but we don't know because she didn't say. And now that they had Brad Holder back on the stand, or Brad Weber back on the stand, they did what she wanted. They confronted him with the statement. They let him read it. So can we have him now? Maybe they'll ask to reconsider. I don't know. Vicky Risch, do you think the defense was successful in convincing the jury that the confessions were due to his condition and or mental status in that prison? I don't know if they've been successful yet. I anticipate that that's going to be probably like the critical issue in the deliberations. That's going to be the deciding factor. Are these confessions reliable or are they not? The jury seems to be, from the videos, pretty impressed. They've had an impact. Those videos have had an impact. And so I think that is going to be the question is people, are maybe going to acknowledge, yeah, okay, maybe he was tortured. Maybe we'll go ahead and look at it that way. But does being tortured mean that everything you confess to is false? That you can't confess to anything that's true? Well, no, it doesn't. It just doesn't guarantee that what you're saying is true. And so I really think it's going to come back down to that, the reasonable doubt. And that's going to be the defense's job in their closing, is to remind them of that and to show them, walk them through the reasonable doubt that all of these circumstances present. He doesn't match the descriptions is a big one. They had to lie about what he said in his interrogation to put him where they wanted when they wanted him there. They can't put his car where they say he says it was, although he never even said it was there. He acknowledges being out on the bridge. A lot of people acknowledge being out on the bridge. A lot of people looked and sounded like Bridge Guy. He's got a .40 caliber, but there's two other .40 calibers, including a completely different brand that couldn't be excluded, including Brad Weber's, who has now put himself at the scene. So I think that's really going to be the linchpin of the case, is do they believe that these confessions are genuine or not? And, I don't know where we're at with that. I think that the doctor's testimony today was very compelling. I thought she was a very strong witness. I didn't think the state particularly landed anything on her. The mischaracterizing, it didn't stick. The doctor just corrected her. The doctor was very prepared. The doctor was very organized, very professional. Real contrast to all the state witnesses who were up there not remembering anything. So, I don't know what they're going to make of it. I really don't. I know what I make of it, but I don't know what the jury is going to make of it. Rochelle D, what did Kelsey mean by they released my audio when the Bridge Guy video was released? How much trial is left? I don't know how much trial is left, and I don't know what Kelsey meant by that. I don't know what context Kelsey said that in. If that was an interview or something, I don't know. My suspicion, I mean, I'm still expecting Dr. Martin. He's on the list. The hint has been there that Dr. Martin would testify, but maybe not. Maybe they got enough from Dr. Westcott as far as the conditions and his diagnosis and so forth. I do think Dr. Martin would be important just because he was treating him at the time. And so to the extent there's any like lingering question about, well, she didn't do her evaluation until August. He was already out of psychosis at that point. Can she really like retroactively diagnose him? Is that really reliable? Then it could be helpful to have Dr. Martin come in as well, because he was treating him, during the midst of all of this. And you don't give Haldol to people that are faking. You give Haldol to people that are psychotic. And this was pretty much acknowledged in Dr. Wanger, her testimony, because she talked about the grave disability is what they were targeting. The inability to function is the fact that he was deteriorating, that required them to intervene, and that grave disability is like a side effect of psychosis. And so that's what they were trying to address with the Haldol. It seems to me to be a pretty clear admission. You guys know he's psychotic. You're just not going to pin a formal diagnosis on him until, however many days down the road, 30 days have elapsed. But you're treating him for psychosis. So that seems to be important to still come as verification. I still think they have something with cell phone forensics, either their own guy, the FBI, something. Because they've hinted at that so much. And they've laid this trap where they've pinned the state's investigators down on the timeline and the fact that, their theory is that the phone never moved after 2:32 and the movement stopped. It would have been left under Abby's body at that time. It would have continued to ping until 5:44, but it never moved again. They just have set that up so much that it leads me to think they have something to suggest it did. I don't know how good it is. I don't know how strong it is, but it suggests they have something. So I'm going to want to know what that is. That's got to be still coming. Other than that, where are we still? Becky Blair with the car. Bring Becky Blair back to talk about the car that she saw in the CPS lot and the time frame, the fact that she did not see a 2016 Ford Focus there. Anybody else? Anything else? I can't really think of. I mean, I do feel like we are getting close to the end, but it's just hard to say without knowing what exactly they have. It's very hard to say how much trial is left. Some guy with cancer. Nancy Grace blocked me for calling her a dumbass over her reporting. I stand firmly behind my words. Well, she's just a confirmation bias reporter. She's got her perspective. She came to court just exactly long enough to see what she wanted to see to confirm what she wanted to report. And she's not interested in the bigger story. So that's all you really need to know about Nancy Grace. Not Turtle. What's up with people saying that Kathy said in the interrogation room to RA, you told me you didn't go to High Bridge that day? I don't know what Kathy said in the interrogation video because it was just too hard to hear her. And I've heard like a lot of different things being attributed to Kathy in that video. I could not hear most of what she said. So I can't speak one way or another to if this is something that she said on the video or not. I just don't know. Truth Seeker, there you are, girl. Love you, Andrea. I told you I'd have you back. I truly meant that. You have to be in there daily, no matter what. You and Lawyer Lee both. I got you both. Girl, you are a rock star, and I appreciate you so much. And I'm so glad I got to meet you through all of this, and I'm so grateful for all your help. And yeah, when this is all said and done, drinks are on me. No question about it. Bowie girl, could you clarify if there was a handkerchief found at the crime scene and why the state didn't test it for DNA? Wouldn't that be a crucial piece of evidence if it didn't belong to Abby and Libby? Thank you. Yes, so this was the green item that was described alternatively as a headscarf or a handkerchief. This was discovered in the river with all of Abby and Libby's clothing. It was the one item that stood out to me because we hadn't really heard it being described as something that either of the girls would have had with them. And so, yeah, it seems like potential provenance of this item is that it would have originated with the killer and then just got disposed with the rest of Abby and Libby's clothes. All we heard about this was from the DNA analyst. I can try to find her specifically. She was day 10. Just so I can get it to you exactly what they did. My recollection is they screened for blood and it came up negative and they did no further testing on that. And the reason why that stood out to me is because, oh wait, no, that's day 10 was Oberg. I think the DNA is 12. Yes, DNA is 12. That stood out to me because she had testified about how the items that were found in the river, there was a low probability of getting results because there's a high likelihood of interference. And interference is going to come from just the environment, the fact that there's been dilution, the fact that there's like dirt, and bacteria in the water, and those things will interfere with the ability to get a good DNA result. But nevertheless, everything else they found in the water, they tested. So, the low probability of a result didn't deter them from doing that. The green scarf, here it is. I have a star by it. Number 72, it appeared to be very old. It was embedded with mud, may not have been related to the crime. Well, we don't know if it was or wasn't, don't we? I mean, if it's found entangled in the branches in the creek in the same area as the clothing, then why would we not err on the side of it might be associated with the crime? So they did a screen for blood or seminal fluid that came back negative, and she did no further analysis with it. And it was the only thing they did no further analysis on. So I don't have an explanation for you about why they didn't. It seems to me like they should. And yeah, it seems to me like that is exactly the kind of thing you would be looking for. Now, one thing we do know is that the testing that's performed at the lab, she made it clear she tests what she's asked to test. She doesn't make it up herself. There's like some kind of preliminary decisions that she can make, some kind of like, path kinds of decisions that she can make. But by and large, it's the investigators who tell her what they want her to test for. So that's what I would want to know. Did they ask you to test this for DNA, or did they leave that out? Because that would be telling. Something that potentially belongs to the killer. And that's something that's the one thing you don't want to know anything about. That would be telling. I mean, just the fact that they didn't do it. The one thing that potentially belongs to the killer is the one thing that you don't follow up on. Glenn F. Indy Star reports that Judge Gull is resigning and not seeking re-election, but will work for Indy Star on a column called Dear Franny. I would have to ask a lot. I would have a lot to ask Dear Franny, but she will likely sustain my questions. I'm assuming this is satire. I mean, I'm telling people, all people want to know what they can do in this situation, because this is a very helpless situation. This is like the system at work, and we feel very trapped by it. So I've been saying a couple things you can do. Exercise your power of the vote. Don't forget what you've seen here. Remember it when these folks who have made these decisions, when it's time for them to come up to the public and persuade you that they deserve another term. Be loud. Bring it up. You can vote these people out. That's a power that you have. I've also gotten questions about where people can direct their resources. Like people want to help, people want to donate. And I 100%, I agree with that. Like support that. Absolutely. Great organizations out there that are available to support that work on these kinds of issues. I put some feelers out to try to get some information about Indiana local organizations, just because, small local nonprofits often have a much harder time getting resources than like big nationals or internationals or things like that do. So the first one that was recommended to me was the Indiana Innocence Project. This is a new branch of the Innocence Project. And so they are, they're like kind of still in startup, and resources would, donations to them would make a big difference. They do excellent work on wrongful conviction, going back and revisiting cases that are sometimes decades old that have been plagued with these kinds of problems that we really shouldn't be still seeing in 2024, but here we are. Bad confessions, bad eyewitness IDs, bad forensics, the most common themes. At least one of those is present in pretty much like nearly every exoneration that the Innocence Project has been involved with. So that's one. Another one I got a recommendation for is a group called Indiana Cure, CURE, and they're an organization that works on behalf of prison conditions. So that's one to potentially look into and see if that is something that you want to support. So these are ways that people can help. It's not a fix. There's really no fix for any of this, though. That's the problem. The problem with criminal cases, and a lot of times with the expectation of justice anyway, is that there's never real justice. Once a crime like this is committed, the justice is already gone. These girls shouldn't have died, and you never get that back. So anything that you get down the road through the system, it's partial, it's incomplete at best. So we're never going to be able to restore things to the way that they were. And we're never going to fix in any of these wrongs that we've seen happen on the stand. But yeah, there are things you can do. You can vote people out. You can put your resources towards groups that are helping on these issues. You can also talk to the legislatures. Go to the legislature. They're the ones that create the Indiana State Police. They're the ones that create the Department of Corrections. They have oversight responsibilities over those organizations. And they're the ones who are responsible for deciding if something needs to be changed, in the structure of how they run, the authority that they have, and so forth. If there needs to be reform, that can and should come from the legislature. So make your voices heard there as well. Make it clear this is absolutely unacceptable. Not in my name, not in my state. No. Change it. Jackie Rice, do you think the defense will again address the trail cam? Seems like a super important aspect to conveniently be left out by the state. That is a good question. I am really hoping that we see the trail cam, just because it would, just to have the visual. Then we can kind of test that against the way it's been described to us. You know, how far really can you see? Can we tell what angle the person would have been walking at? Do we have information that can tell us where the camera was oriented? Because I certainly don't trust Steve Mullen to tell me anything truthfully at this point. I would like to know more about that. Yeah. It's just what I don't know. You know, I don't know. It was kind of a big bomb for the defense to bring up, you know, for the first time in the defense case. But it's possible that maybe they did that because it's sort of a dud. You know, it isn't really anything, and so you just kind of get what you can out of it in your cross. But it seems very significant to me. I would want to know, like, what time were these? Because he said it was who we think is a fireman. We couldn't quite hear what was said, but multiple people heard fireman. That it was a fireman who walked across it on the 14th. But then there's a possibility of someone also on the 13th. I mean, I'd like to see, because that's starting to sound like a lot of people in pretty close proximity to where the girls were, if they were there. So yeah, that's a very good point, and I hope that they do address it. If they don't, I'll assume that there is some reason for that it's just not as favorable, you know, maybe as it sounds on first glance. But I think it's worth showing to us, just so that we can evaluate it with our own eyes. Heidi Marie with the super sticker. Thank you so much for that. Debbie W. One thing that confused me is that the doctor said RA didn't want to leave his cell, but having to go into his cell was one of his triggers. I'm having trouble reconciling that. So it was Dr. Walla that said that going into his cell was one of his triggers, and it was Dr. Westcott who said he didn't want to leave his cell. And so I'm not sure if these are talking about the same time frame. I think once again, his not wanting to leave the cell was during the early part of his stay there, when he was starting to show this deterioration, but it hadn't gotten to the point of the full psychosis yet. When Dr. Walla was talking about the triggers, she was talking about his behaviors, like his unusual behaviors, his weird behaviors. And I think just the crying, you know, he would be crying, he would be upset. So yeah, it would have been nice. I agree. It would have been nice to maybe have those things tied together. All I can really tell you is Dr. Westcott said she took Dr. Walla's observations and notes into consideration, but she also weighed it against everything else. So I don't know. I think if there is a conflict, then it's a situation where it may come down to a credibility issue. Like, it may come down to, is there a possible way to reconcile it? And I think there is. I think you look at the reconciliation as just the time frame. But if there's not, especially also because Dr. Walla had most of her contact with Rick Allen after he was already on suicide watch. And so this was after, you know, he had started to go through that deterioration. But if you can't, you know, if for some reason that's not satisfactory, we can't reconcile that, well, then it comes down to who do you believe? And Dr. Walla, you know, had a lot of problems with her credibility, and Dr. Westcott was pretty impressive. It just really didn't land anything on her. Lily Ristano has gifted a Andrea Burkhart membership. Thank you for that. Kelly Jane, searchers' phones overloaded servers. So Libby's phone was waitlisted like New Year's when we all get loads of texts at 4 a.m. It does seem like a logical explanation to me. Now, the search ended around 2, that would be kind of my question about that as far as just the time frame. If the issue was the volume, then you would expect that once once the search was over, the volume would go down. And then once the volume would go down, she'd be able to reconnect. And so why would it take almost another 3 hours to reconnect? That's the only like kind of, not sure part I have about that from just a logical view of it. I sure wish they'd gotten those tower records. Seems like good information to have. Seems like those tower records should still be available. They followed up on the forward focuses after the jury asked that question. Why not follow up on the towers? They already got experts. I don't know, maybe not a tower expert. But yeah, this does seem like a very viable explanation for me that would need to be ruled out somehow. If if we're going to buy the defense theory that the timing means that the phone left the area. We know it didn't die because it came back on the next morning. So the other explanation is left the area. You got to rule out to me that this is a tower problem. Heidi Opp with a super chat. Thank you so much for that. Violet became a YouTube member. Welcome to the channel. Jen Lee 143. My theory, Brad Holder's ex-friend took Brad's son Logan to take care of Abby. Elvis tagged along. Thoughts? I mean, any of this is possible. It's just hard to say because we don't have evidence because they didn't follow up on it. They followed it so far and then they let it go. They never searched the phones. Information that would have been very helpful to get. But it's just without that, I don't think there's, ever going to be a way to sort it together. Oh, maybe someday somebody would, if it's the Odinist theory is correct, that's a lot of people involved. You have a prisoner's dilemma kind of problem. Maybe one of these guys someday, for some reason, decides, okay, I'll go ahead and tell. But then you just kind of run into the same problem of, words. Talk is cheap. Talk is cheap. People can kind of say anything, especially like when their skin is on the line. So how do you verify? How do you validate that, even if you got something like that? At this point, I don't know how you do. I just don't know. Kate's Meow, you have a gift and we are all so grateful for your dedication. Do we know who else may be called by a defense to testify? Dr. Martin, FBI, Murphy. So yeah, we heard today there won't be Murphy. Won't be him. I think he was mostly an Odinist expert anyway, but he could have given some insight into the investigation. I don't agree with that cumulative objection being sustained. It might be that we could still hear from him about something, possibly the, we've heard from a few of the witnesses now. The defense is clearly implying that the police weren't really interested in following up and getting the information from them. Only talked to them twice, had a hard time trying to get the police to pay attention. Then when the police showed up, they're more interested in the fact that, Cheyenne's boyfriend was in prison, that kind of thing. So it seems like Kevin Murphy could potentially add something to that from the perspective of somebody being involved in the investigation. Did it seem like they were not pursuing leads? Did it seem like they were, suppressing certain angles? I mean, they can't get into the Odinism though. So I don't know. I don't know if we're going to hear from him. FBI, probably not getting Poole, not at this point. If he can't testify remotely, we're just about to be in the middle of the election. Dr. Martin, yeah, I think is likely. And then beyond that, really don't know. It's hard to say. It's really hard to say. PDF photography. Is there a time frame on when you can pull activity data from cell records, like confirming RA, looking at stocks, text messages, etc.? Was 2022 too late? So the problem is a lot of that information you're probably not going to get from the cell records. You might be able to get from the ISP. But mostly you need his phone. And so that's the problem. You get the information about where his phone, what his phone was doing from his phone. To be able to get something like the stock information, they can go through the other way, back end it. But what they would have to do is they would have to know his account information. They might be able to get it through the device identification. But basically what you typically would have to do is you'd have to get his account information and go to, whoever is the app provider and subpoena it from them. So it's not necessarily impossible. Those things can be difficult. App companies go out of business all the time. That can be a real problem with getting things like this. Well, it doesn't exist anymore. If this wasn't a particularly successful app, then it may not still be there. They are going to have, varying record keeping requirements. I mean, I could be wrong, but I'm not aware of any like federal law that requires, retention of data for a certain period of time. It's pretty much what the companies want to do. And I don't know what their practice is, what their time frame is likely to be. Obviously the more that they store, the more just the more it costs in terms of you have to, buy the server space to store all that data. But also the more you save, the more susceptible you are to legal inquiries. Because if you got it, you got to produce it. If you don't have it, you don't. So it's kind of the easy path potentially to just, keep less rather than more. So I don't really know. But I wouldn't think 2022, if they did want to go down that road, even without his, if he was, and he would seem to be very, give him his phone passcode. It was only when they, start to say like, yeah, we also want to search your house, that he's like, okay, wait a minute. Sounds like you guys are focusing on me. Maybe we're not going to go any further down this road before I talk to my wife. But he'd been very accommodating with his account information and stuff. So why not provide this? Doesn't seem like much of a downside to him. Jennifer Ferguson, you don't need to treat us, but all of us locals need to get together there with you before you go home. Well, I will treat you anyway, but yes, I agree. I agree that we should. It would be my honor and pleasure to do that. So, Auto Doctor 911, how have you looked at the tarot card to compare with MScene? So I have. This is something that I mentioned way back, that something about Abby's pose, it reminded me of the Hanged Man, the tarot card. And so a lot of people responded to that. Apparently there's like a Brad Holder social media post of the Hanged Man. The Hanged Man is associated with Odin. Apparently, like, the Hanged Man is Odin in some interpretations. Like, I didn't know any of this stuff. I had no idea like these links were out there. From that, folks pointed out then that that Abby or Libby would potentially correspond with the Magician card. That one to me looks like a little bit more of a stretch, because the only commonality is really the outstretched arm. But I have thought about that, and the Hanged Man, and kind of the significance of that and what that could mean. For the folks that are interested in the tarot angle, one of the thoughts that I had was that if, like, hypothetically, if this is correct, and Abby is intended to represent the Hanged Man and Libby is intended to represent the Magician, their orientation is the same on the ground, but the orientation of the tarot cards is the opposite, because the Hanged Man is upside down. And so what it would tell us is that one of these figures is inverted. It's the card in the inverted position. And I don't know that we know which one that would be, or what the possible significance of that would be. But I do just put that out there as kind of one of the thoughts that I had about the tarot theory. I am a little bit more skeptical on Libby, but Abby, I mean, yeah, That occurred to me like just kind of immediately from her posture and the way, the kind of strange position her arms were in, and the fact that the blood is flowing upside down suggests an inversion. It looks like the Hanged Man. So I definitely understand that perspective. Pamela Wolf with a super chat. Thank you so much for that, Pamela. Six Kids UK. I still have a question about the trail cam. In my experience, torture can make a person fixated on a certain answer even after the person is physically safe. I can believe that. I can believe that. I mean, safety and security, when those get undermined, yeah, that can stick with you for a long time. A long time. I mean, I wouldn't be surprised at all if there's some kind of like PTSD at play here. He's already a highly anxious man, apparently. You know, was before he ever went into prison. Having these experiences and these breaks. Yeah. I could see that. I mean, if you've been conditioned through that type of experience to say or to accept something, then I don't know that just instantly goes away. I mean, in any event, the testimony was this type of psychosis. Once there is a break like this, it is it's potentially an ebb and flow, highly likely to occur when there's more stress. You think there's stress also in Wabash? Yeah, I bet there is. He's further away from his wife. He's further away from his lawyers. He's even more distant. Auto Doctor 911. To me, confessions are the weakest of evidence there. They're pretty weak. I would put eyewitness identifications, honestly, as weaker than confessions. Just because, I mean, some confessions are true. You know, it's not that eyewitness identifications never are. It's just that they're kind of always inherently problematic. You know, people miss details. There's been so much research on that. The whole oh boy, now I'm spacing on her name, and she's like my idol. The doctor who does the recovered memories. I did get more sleep, but it's still not like all my sleep. So I can't quite remember off the top of my head. Doctor. She's a lady. She's testified for all kinds of people. She was in that Showtime series that I'm also now spacing. Anyway, Loftus. Yes, thank you, Elizabeth Loftus. Thank you, chat. You are a lifesaver. God, I love this chat. Elizabeth Loftus. Done so much studies about eyewitness identifications and just how bad they are and how easily tainted they are. How you can, you know, show the same thing to five different people and they will all have different impressions of it, and then you can like use different words to describe it and they'll remember it differently. Like eyewitness identification is just really poor. But yeah, confessions. It's circumstantial, you know. I mean, sometimes they are legitimate. I mean, technically, I guess if you think about it, every guilty plea that's not an Alford plea, you know, an Alford plea is where you plead guilty, but you say, I'm not conceding that I did it. I'm just saying the state has enough evidence to convict me. Every plea besides a guilty plea is in some way a confession. And there's an awful lot of those that go through the system. That said, a lot of people will plead guilty and it's not an Alford plea and they'll still, you know, insist they didn't do it and we're hard done by and everything. But yeah, they're not great. They're not great. But then under circumstances like this, no, just really not very reliable. Zach Butson, I'm starting to have doubt that Rick is the guy. I know the feeling. I know the feeling when the state rested, because I kept hearing, and I think a lot of people had this expectation that there's like going to be so much more. There's lots more. They even said it. I was on Grizzly Gisela's Grizzly True Crime the other day on Sunday, and she's got a whole bunch of the clips from the press conferences from the early days, and it even comes up in these early press conferences about there's potentially all these other people involved, and there's many tentacles to it, and it's very complex, and all this kind of stuff like that. But even then, just this kind of hint, you're seeing this, and there's all this other. We're not going to tell you all the, all the stuff we have. There's just been the suggestion that there's, some mountain of evidence that's been hiding. And, where have I heard about a mountain of evidence before that never materialized? Huh? Hey, my Johnny Depp people, remember that mountain of evidence that never materialized? That's what I feel is kind of the situation here. So I think there was a big expectation that we just had to wait till trial, and that there was more that we didn't know about, and they would lay it all on the table, and then it would be clear, and it would be overwhelming evidence. That hasn't happened. So even up to the day the state was resting, I was hearing from people about all this stuff that was still going to come out, yet to come. And I'm going, I don't know about that, because like that witness, for example, already testified and we didn't hear any of that. And this other stuff, yeah, I don't know about that. I don't know that that's coming into court. A lot of people with a lot of confidence about the law and the legal process. It's not going the way that they had predicted. So I understand completely. Once the state rested, and I'm like, that's it. Yeah, I got a lot of doubt that Rick is the guy. Stephanie with a super chat. Thank you so much for that. Rumor has it the jury will never know about Screamin' and Labrato's detailed descriptions of his care. Judge Gold's hand-picked replacements of Rosie and Baldwin agreed with them. Yeah, It really made them more believable. Yeah, it did. The attorneys that she handpicked after she kicked Baldwin and Rosie off the case were like, yeah, we kind of think he's probably innocent. This should be what we call a clue. A clue. The problem is not these defense lawyers making stuff up or whatever, being unreasonable. There's a reason why everyone who got their hands on this file was like, not so sure about this one. And yeah, the jury never gets to know about that, the whole procedural background of the case and all that. So much they're never going to know about this case. Stephanie with a super chat. Thank you so much for that. Inexplicable Susan, can you confirm that the only male DNA found on one of the girls was not from a lab worker? Did they name the ISP personnel that it belonged to? Thank you so much for your comprehensive coverage for all of us. So it's not exactly that the only male DNA that was found belonged to a lab worker. There was a fair amount of male DNA found, and there was a number of mixtures that raised the question about the possibility of more than one male, more than one person. But the only male DNA from which they were able to develop a profile was connected to the lab worker. It was matched to the lab worker. No, they did not name the lab worker. They said it's their policy not to do that, to keep it confidential. So we don't know who it was, but that was the only one they could develop a profile from. But it was not the only male DNA. There was quite a bit of male DNA that was located, and some of it in mixtures. So suggesting like multiple individuals. Just not high quality enough DNA to be able to develop a profile from it, or high quantity DNA to be able to develop a profile from it. Ray, I was prescribed Haldol for uncontrollable vomiting in ER before. They told me I'd get tired. I had the complete opposite reaction and went absolutely crazy. It's now on my allergy list. Worst experience ever. Yeah, that doesn't sound very pleasant. I do remember reading a few years back that there was, it might have been a lawsuit, or it might have just been like a whistleblower report kind of thing, but that when Department of Homeland Security would deport people, and I mean like not the legal process of deport, but the actual like putting them on the plane to send them back home, when people would resist, they would shoot them up with Haldol. And that's because it typically has such a strong tranquilizing effect. They could then just, get them on the plane, and they wouldn't misbehave. And then whenever they land, wherever their home country is or wherever they're being taken to, then it's that place's problem and not DHS's. So, yeah, pretty horrible stuff. But that does sound like a very unpleasant reaction. Justin Maxwell, welcome to Team Sharpie S Gel. Thank you. I'm not trying to be like I'm not like disloyal or anything. But I mean, my gosh, this is a really nice pen. Christy, a painter's daughter. I was told fumes from Sharpies cause contamination. That's interesting. Yeah, I'm gonna have to look into this now. That's really fascinating. I'm gonna follow up on that, because this is a development I have not heard about, so I want to learn more. People in court, thank God we have a strong woman who can and will hand a shady judge her whole ass. Well, we'll see about that. It's going to be up to the court, and they got a lot of reasons not to pay attention to what I have to say. And there are a lot of procedural ways that they can potentially avoid not having to address what I've brought to their attention if they don't want to do that. Ultimately, their power is to sit on it for as long as they want and not really give me a ruling. And there's not really anything I can do about that. So there's a lot of ways that things can go sideways, but we just wait and see and be patient. Pamela Wolf, Nancy Grace, are there people that are not happy of you sharing so people see the whole picture? I am praying the jury sees through this shit show. I mean, there's always going to be people that don't like what I have to say. That's life. That comes with, 7,800 people watching right now on the stream. People pay attention to what you say. Other people are going to have a problem with that, going to criticize it, especially if they don't necessarily like what I have to say. And, I've been sharing all the facts with you, but I've also been sharing with you my reasoning process as I work through those facts and the conclusions it's led me to. And so if those conclusions are the things that are offensive to some people because, they don't want to maybe have to engage with these facts, then yeah, those people are haters. And so that's, a real good sign. A good sign of cognitive dissonance is people getting angry. When people get angry over facts, or they, name call, things like that, they start to do these hateful things. It's a tell. It's not a guarantee, not every time, but it can be a pretty good tell that this is somebody who has a view of reality that they are struggling to reconcile with the facts. And that creates discomfort because they don't want to let go of that idea. And so being continually confronted with the facts, that can make people angry. It's just life, how it goes. It's nothing to take personally by yourself. Hating says nothing about anybody at all except the hater. Kim McMillan, could the defense say, was there any social media pics that resembled the crime scene that you happened to see? No, they would probably get reprimanded for doing that. Because of the ruling, they've been on notice that they're not allowed to go down that road. So don't see that happening. Buffy, I've listened to Bob Ruff's podcast, which is how I was turned on to Bob Motta, Lawyer Lee, and you. I don't know how you take such detailed notes, but best note taker. My whole perspective has changed. I just sprint. I'm a sprint note taker. I don't know, just a lot of practice. I've been doing it for a long time. When I sit at trial and I'm listening to the witnesses, the state's got them on direct. I want to get down everything that they say because that's my fuel for cross. That's what I have to respond to in my cross-examination. So I want to be thorough. And so I've been doing that for a lot of years, and this isn't really that different than what I've been doing in that kind of context before. But I'm glad you found us. I'm especially glad you found me through such good company. Rochelle D. Kathy took Bob to the exact place that they park at when they go to the trails, and it is easy access. Rick Allen did not park at CPS. Are they allowed to show the jury on the map or a video? They can if they have testimony. So if Kathy is going to testify and she's going to point out things like this, then yeah, they absolutely could. Absolutely. Holy Hannah, did anyone actually witness A and L on the trail? Betsy Blair did. Betsy Blair is the only one that we know that actually saw Abby and Libby on the trail. That's why she is such an important part of the timeline, because when she left and went by the CPS lot, that's where Rick's car is supposed to be, according to the state. And she does not see a Ford Focus. She sees a car that reminds her of her dad's old 1960s Mercury Comet, which looks absolutely nothing like a little black Ford hatchback. So she is the one that has the closest time frame. Her description of Bridge Guy is the one that gave us the second illustration. The young guy with the poofy brown hair, in his 20s, tall, beautiful visage, beautiful. Anyone, thank you for all your hard work on this case. You put Nancy Grace and Pat Brown to shame. Well, thank you. I mean, that's frankly a low bar because all I needed to do was show up to exceed that standard. Alita, so much injustice in this sad case. I'm still appalled that Dr. Walla called the psych patient suicide gown a kimono as if it is a luxury. Thank you for being a beacon of light and compassion. Yeah, when I heard about these gowns and the way that they were described, the Flintstones gown I thought was a pretty good description, but in my mind, it was the One Flew Over the Cuckoo's Nest is what came to my mind. It was the One Flew Over the Cuckoo's Nest gown. When they end up in the, like lobotomy room and stuff like that, and they got this gown. That's just what I remember anyway. That might not even be correct from the movie, but I have a vision of it in my head. That just goes to show you how memory is such an elastic and funny thing. I don't even know if it's true or not, but I can see it like it's in the movie. Anyway, yeah, like it's some upscale kind of thing, a kimono. Oops. Heather S. Re-voting. It's been difficult to find info about judges on the ballot. I'm in a big city and there are 46 plus positions just this election. Only using party lines feel insufficient. Any resources? Ballotopedia is probably the best place to start for just kind of a comprehensive source on election candidates. They're the only ones I know of that really have information like, relatively detailed information about judicial candidates, at least like local judicial candidates. If you get up at the higher levels of court, like the Supreme Courts and stuff like that, then you might get places like Judicial Watch, keeping an eye on some of them, but I mean, not really, because they're just more focused on process. But the higher up you go, the more likely it's going to be that you can find good information. But as far as like a local judge running, it can be very difficult. So Ballotopedia is a place to start. At this point in the election, I'm not really sure what to tell you. Like, the judges will often have forums, candidates forums like everybody else. Do interviews and stuff like somebody else. Some of these things can be a little bit difficult to access if you aren't really looking for them. So check out the campaign, their campaign web pages, because they'll often have like links for things that they appeared to and town halls they did, or things along those lines. I mean, judges don't really do town halls. I mean, they kind of do, I guess. Sometimes it's not totally unheard of. So you can find some information about that through the campaign, bearing in mind, what you get is going to be cultivated. It's they're not going to show you like the time the candidate bombed. they're going to leave that one off. You got to go to the opponent's website for that one. So those are some places to look. If you have local organizations that are just involved in ranking candidates, I'm thinking of when I was in a small town, we had, I can't remember exactly what they were called. It was something like the Grandmother's Circle, something like that. Their focus was on trying to bring a bipartisan perspective to different issues, and so they would have these events where they would put they would try to get somebody from like each side of the aisle, so to speak, to like present on a certain issue or talk about the differences in their positions and stuff like that. So there are things like that out there. If you can hunt those down, those are really the things that come to the top of my mind. If you know lawyers, ask them. Ask them, which judge should I vote for? If you know people that have been in court for any reason, had a divorce, had a civil case, had a criminal case, ask them about their experience with the judge. If one of the judges that's running is an incumbent, you can find that out. Ideally, to select judges, the best thing to do would be to just take some time to get to know your local courtroom. And it's not really any different from like going to city council meetings or something like that. Things to monitor, people do to monitor what your government is doing and to be informed. You can do the same thing in the court. Spend a good amount of time, like go every, I don't know, Tuesday morning or whatever. Look up your court to find out like what their schedule is and when they hold different dockets at different times and stuff, because they might not actually have court on Tuesday morning. But if you do something like that over an extended period of time, you can start to get a feel for how your court process works, how the personalities are, how the people relate to each other. Is there tension here? Do people seem to get along pretty well, work pretty well together? Does everybody seem pretty reasonable? There's really no substitute for that. So I definitely encourage people, take an interest in your local courtrooms, just like you would take an interest in your city council, your planning committee meetings, all of those things like that. Kari Mache, Rick said something about he had an affair. This could cause serious mental and spiritual maladies. Well, this was when he was in his psychotic state and he was, ranting, and he said something about dear God, I'll never cheat on my wife again. It's not clear to me that this is a real thing, like so many of these other things that he's ranting about during his psychosis. They're not grounded in reality. So I'm not convinced that this one is either. Starlight Selenite, Libby also looks posed like the Statue of Liberty. Possibly, yeah. Possibly. ACSW, previous Judge Diener, relation to prosecutor. I think there is a relation here. Wasn't it the father or the brother or something like that? Stepped down due to concern for family safety. Do you know about this? Thank you so much, AB. Love from Oregon. I don't recall offhand. I thought it had to do with just connection to the case. I didn't think it had to do with safety, but I will look and see real fast if I can find that. Because it did come up pretty early on. I want to say that was... Okay, so Judge Diener is still on October 28th. Sets the hearing, enters the safekeeping order. It's based on a toxic and harmful insistence on public information about the defendant in this case. So it's the public's fault, according to Judge Diener, that Richard Allen needed to go into solitary confinement. This is a very bizarre order. It was very bizarre. Anyway, order of recusal and certification to Indiana Supreme Court for selection of a special judge outside of Carroll County, dated November 3rd, 2022. The judge of Carroll Circuit Court has determined that the particular circumstances within the underlying case warrant recusal and dictate that a special judge be appointed in this case. The court hereby recuses itself pursuant to the statute citation. This court has determined that no judicial officer within the county may preside over this case. This court now certifies this matter to the Indiana Supreme Court for appointment of a special judge in compliance with some other statutes. So ordered 3rd day of November. So he doesn't say specifically other than particular circumstances with the underlying case. I'm going to look and see real quick if I can find this statute. LR. Yeah. Not real quickly. It's a local rule. So it's a Carroll County local rule 08 CR 13. Let me see if I can find it. CR 1319, special judges, page 20. Let me look. This rule shall apply to the reassignment of the case and the selection of special judges in felony and misdemeanor cases where a change of judge is granted or an order of recusal or disqualification is entered in the case. Special judge shall be selected from Section A. If no judge qualifies, then on selection Section B. If no judge qualifies, then under Section C. So A is either the Carroll Circuit Court or the Carroll Superior Court, which is like the inferior court here in Indiana. So he just basically determined, for whatever reason, because of the circumstances of the case, that neither of them could preside over it. Then it says the Section B is that the Carroll courts shall maintain lists of eligible judges, including judges regularly presiding over criminal cases within the administrative district and from contiguous counties who preside over criminal cases, and shall assign a judge from said list on a rotating basis. I don't know why that wasn't adequate. He really didn't say. He just said due to the underlying circumstances of the case. So I don't know if that just means it's too close to home, there's too much press, not enough security. It's very ambiguous. It's very ambiguous what his grounds were. So that doesn't really answer your question, but I don't think we can say why he stepped down. The record just isn't particularly clear. Caitlin Bunk, I wish something could be done about the awful law enforcement work on this case. Thank you so much for your coverage, and thank you for the line sitters who helped make it possible. Yeah, what's done is done, and you can't go back and get it over, and it's very, very unfortunate. It makes it very difficult to conclude that this process is likely to produce justice for these girls. Erica M., how could the Emmy not give a better time of death than any time between the last phone movement and when we found them? Lividity would be fully fixed at one of those times and not fixed at all at the other. Yeah, it does seem like something they should have narrowed down a little bit more. One of the things I've mentioned is that they did take a crime scene photo where they moved Livy's body. They rotated her up, and she was covered with quite a lot of debris, leaves, a lot of leaves stuck to her. But I did notice immediately when we see this picture, there is no sign of lividity, and there is a sign of lividity later on when she's having the autopsy. So maybe that's another person the defense has. Does the defense have a pathologist? I don't know. It could maybe help narrow it down. That's another potential direction for them to go. I just don't know if that's something that they have available. Auto Doctor 911, confessions are just easy to dismiss in this case, easier to dismiss in this case than gun and admission of being there. I don't think there was any real eyewitness testimony here. Well, I mean, I hope you're right. I think a lot of people find that confession to be extremely compelling. You know, people think to themselves, I'd never say I did something I didn't do. And that carries a lot of weight with them. The gun, I can see the bullet being dismissed because the bullet, no, we're just kind of guessing that a gun was related to the crime at all. We don't know. It's one possible interpretation. The police officers say they think that somebody on the bridge guy video says something about a gun. I don't hear it. I don't know. I'm not going to get to listen to it 100,000 times like they did. But I'm not taking their word for it at this point, like I've already said. And yeah, his admission that he was there that day, that's ultimately, what caught him in the net. Had he never come forward and said, I was there on the bridge that day and here's what I saw, probably wouldn't be sitting here today. John Beattybot, did I hear you say judge denied third-party Elvis's confession because no DNA? Can we trust appellate process to right corrupt judging, or will she skate? I'm very skeptical that this third-party ruling survives appellate review. It's just too much of a connection. Like, she's saying there's no nexus, but like Mr. Baldwin's pointing out, you're not saying why. And the case law just says it has to be a direct connection that is not, speculative. And somebody confessing to the crime is a direct connection that's not speculative. They said so. So, yeah, she did. There's no direct connection, no DNA. That's right. That's correct. Thank you, Judge. Just like there's no Richard Allen DNA. KH, thank you for your honest coverage. Thank you so much for your support. I really appreciate that. Bridget Wainwright, I'm happy to convert your notes to text so you can control F. I am in Australia, though, so they need to be scanned, which is half the work. Yeah, and I don't have a scanner here. So I know there's a lot of people that have been wanting to have my notes, to archive them and stuff like that. And the only way to be able to deal with that at this point would be to photo them. And I don't have the time. I don't have the time to do it. But I will keep them, of course. And I'm going to have to ship them back home. I don't think they're going to make it in my suitcase. They're going to put me overweight. But they will still be here. 6 Kids UK. As a barrister, my job number 1 is to show the prosecution witnesses and prosecution as mean, biased, incompetent, stupid liars with no imagination. As a prosecutor, I needed not to be like that. Juries see that. Yeah. I mean, the way I've been putting this whole thing is that the trial is really just about trust building with the jury and who does a better job of gaining and keeping their trust. You can gain their trust all you want with your charm routine in the jury selection, but they start to question the case that you put on and the representations and the way that you're skewing things and the stuff that you're not showing them. Yeah, that's how you lose trust. And so that's a big part of the competition sometimes between the lawyers, is showing I'm more trustworthy than that guy is. True crime fangirl, wouldn't the list log in the file cabinet not handed over be a discovery issue? Well, I would think so. Yes, I would think so. And the misrepresentation of the facts to the court, to normal courts, that would be a big problem. Coming in saying, I testified to this thing under oath and oops, I mean, I hadn't apparently even checked, found out later it's not true and I never bothered to correct that. Normally, like if I'm a lawyer and I make a false representation of fact to the court, maybe it's not intentional, but I find out after the fact, I have a duty to correct that. And you would think that an honest law enforcement officer with integrity, would be in the same boat. And that the prosecutor who handles that stuff on behalf of the investigator would have that duty. But it just doesn't seem to be important in this particular courtroom. Mariana Galligani, FYI, Loftus is criticized by some in the psychology community for ethics violation, and she left the APA when an ethics complaint was lodged. I am aware of that. There's quite a long history about that. She's talked about it extensively. She definitely has her own account of all of that. So yeah, it's something to bear in mind and something to keep in mind. I tend to think she gets more criticized just because she's an expert. You hire her, she will come and testify about what she knows about memory, repressed memory, false memories, all that type of thing. And so, yeah, she's testified for folks like Harvey Weinstein. Her position on that is that she's there to testify to the science. The science, is the science. It may or may not benefit a person. And so if somebody thinks it benefits them to have the science presented to the jury, then she will do that. But I understand expert witnesses kind of always draw fire. And, she has certainly drawn her share of criticism. Jean Marie, Abby didn't have blood on her. She could have been held upside down when cut. Hanged man in ritual. That's apparently conspiracy theory stuff, according to what I hear from the people that have insisted that Richard Allen is guilty because of all the stuff the state has that they haven't shown us. Brandy Dute, Andrea, thank you for being you. Heartbreaking the hell they've put him through in an effort to feast on his weak points. So troubling. Injustice anywhere threatens justice everywhere. Free Richard Allen. Free RA. Yeah. Well, thank you for the nice compliment. It is heartbreaking, and it's unacceptable. It's inhumane. Really no excuse for this to happen in America. Odin's daughter and Anna Lee. It's always someone else's fault in this case. It certainly is with Mr. Mullen. Certainly is with Mr. Mullen. He couldn't pass the buck. Couldn't pass the buck on that change of the testimony, though. I had to just acknowledge. Very different testimony he gave today, or he gave last week, than he gave in that March hearing. Excited utterance. Andrea, can you give us a sense of how the lawyers are relating to the jury? Are they likable? Does anyone have a better courtroom presence than others? Looking forward to seeing you when this is done. I definitely noticed Mr. Baldwin is the most, from my impression, like direct interaction with the jury. Like he will turn and give the jury a look when something happens. Like there was a moment when he had Mullen on the stand this last time, and we'd established that he'd had these 2 phone calls with, it was when he claimed to have written a report about, what had happened to the interviews and the process that they had gone through to address that after all those interviews were lost. He had written the 2 different reports, but he didn't date them. And so there was a later point when he was asking about the phone call to Brad Weber and how you didn't record that. And so we don't really know what you said. And Mr. Mullen's like, well, but I put it in my report. And Mr. Baldwin says, did you date that? And he said, yes. And so then Mr. Baldwin turns and looks at the jury, the knowing look at the jury when he said that. So in that sense, he seems to have the most interaction. I did comment earlier about the body language that I saw from the one juror that was very pointed at Mr. Baldwin. It's different. Like normally they will swivel heads watching what's going on, but they don't necessarily turn their whole body towards him. This particular juror did that. That seems to suggest affinity for me, but who knows? Just could be that he was comfortable in that position. You can't really draw hard conclusions from that. The jury's hard to read. I think my impression is that Mr. McLeland came across far more likable in the early stages of the case, and that he has really damaged that as the case has gone on. And some of that it's frankly, a lot self-inflicted because it's the case and how he's chosen to present the case. It's come across as misleading. So I think that does, tend to generate mistrust. But then he just also has kind of a way of objecting. It's just very smarmy. He's very smarmy with his tone. Judge, I'm objecting. I don't see the relevance of any of this. And it's like, well, the jury might see the relevance. The jury might get it and might want to hear this. And so for you to be all like snotty about questions that, kind of seem pretty good, but we know you don't want them being asked because, it's not beneficial to your case, just might not be the best way to get the jury's hearts and minds. As a persuader, you need to pace and lead. You need to be on the same. You need to be able to put yourself in the shoes of the jury and think about what they would want to see and what they would want to hear. And then from that position, you can take them wherever you want to go that your case will allow. But this, to me, this approach, this kind of smarmy approach that it's like, I'm just gonna like act like I have contempt for the defense's case. This tends to not be very effective, because if parts of the case are landing with the jury, then they just now see you as not in alignment with them. You're out of touch. And if you're out of touch, then that's just one more reason why they aren't necessarily going to trust you. They aren't necessarily going to like you. Can't say I've gotten real strong impressions from the other lawyers as far as how the jury might be reacting to them. Can't say I've had really strong impressions that way. They have been, by and large, a very deadpan jury. Mudbug, if the drink's on you, then let me purchase one. Thank you, Andrea. Well, bless you. There will be plenty to go around, I hope. Margie, someone reported that the hair in Abby's hand was from Libby's sister. That is correct. However, I was under the impression that the hair was not tested. Thoughts? They did apparently test it in the couple of days between when this came out in the voir dire, in the jury selection and the opening statements, and then the time that the DNA analyst was on the stand. They did complete the testing. They did say that it belongs to Kelsey. Cheryl Butler, don't ship your notes. They're too valuable, and now it's out there. You're mailing them. Well, that's a good point. All right. I'll keep them in my suitcase. I can make room. I can ship other stuff. I can ship like my clothes that nobody wants anyway. Bone Arrow 82. Hey, Andrea, do appellate motions have a word page limit? Typically, yes, they do. Because I think this will be a phone book worth of appeals. Thanks for your coverage. Greetings from Costa Rica. There will be a lot. So you can typically file a motion to just get permission to file a brief that's over length, beyond the page limits or the word limits. And you just explain to the judge the reasons why. It's usually granted. Sometimes they'll be like, you want 75 pages, I'll give you 70, just like make you edit more or whatever. Because they don't want you taking up a lot of extra page and word space just because you're being verbose. But if you explain like, look, there are X number of discrete issues and they're not necessarily related legally, so each requires a separate exposition of the law and an analysis and so forth. It's just, more than you can really do. Then they'll typically accommodate that. Genji Probs, has anyone asked about Bridge Guy's facial hair? A long goatee would likely stick out. Also, a mask would have been less common in 2017 pre-COVID. Yeah, a mask over the face would have been not so common before COVID. That is true. So the pictures of Richard Allen that were put into evidence today, I don't know. I couldn't see them. So I don't know if he's got a goatee in them or not. We know he has a goatee in 2022, but I don't know if he had a goatee in 2017 or what his facial hair situation was. Bridge Guy is so hard. He's so indistinct. It's so hard to really get detail from that picture. From my perspective, it would be hard for me to have any confidence about the ability to even say if he has facial hair or not, just because shadows can do things, the angle that the picture is at, just not super, super clear to me. So Poet's dreams before the trial, I was 75% sure they had the right guy, but hearing the evidence, I'm 99% sure they have the wrong man. I'm appalled at the injustice. That's what the trial will do. The evidence is out and makes you, sometimes will do that, make you question what you thought you knew going in. I mean, you're not alone. I walked into this thinking, you know, I'm certainly open to it. There's stuff here that doesn't look good. You know, I don't know how they're going to explain it. I'm willing to listen and hear. And just, yeah, the more it's gone on, it's not even been so much that the state or that the defense has put on a case that's convinced me. It's that the state's case has fallen apart. That's really the problem. The state's case has fallen apart. All of the little details that they're lying about, the lying by the state is like one of the biggest things for me, because how now am I supposed to rely on you? And why? Why would you need to? If this is the guy, you don't need to do that. You can just tell me honestly what your evidence is. And so it's like, it's this very manipulative situation where it's like, you don't want me to think for myself. So you're trying to mislead me. And they're continuing to do this on the stand with the gaslighting, telling us that, Richard Allen said stuff that he clearly didn't say in the interview we all listened to, that the ballistics report says something other than it says that the expert testified to. You wouldn't need to go to these lengths if you just simply have a decent case. And I recognize not every case is a strong case, but you just don't help yourself with these kinds of tactics. It doesn't give me confidence that I should resolve doubts in your favor. Rich Buddy, he'd be in prison while the hair wasn't tested. What if it belonged to another male this whole time? Tells you they were never looking for the killer. Yeah. Not just that hair, but remember there's all these little details, like they had microscopic hair analysis available. They had unknown hair that they recovered from the crime scene that did not match Abby or Libby. Human hair. And they have Richard Allen right there in prison. And do they ever get his hair and test it? No. And they have these, we heard all about these rootless hair technologies now to be able to extract DNA from the sheath of the hair and do a DNA comparison. And the analyst went and called the labs and got the information about it and presented it to the investigators, and they did nothing. We heard about how the cell phone extraction from Cecil, the FBI asked for it. FBI with all their resources, they can probably help. Yeah, never followed up on that. It does look like they didn't want to solve the crime. And that's unfortunate, because that is exactly what is going to fuel what are being so-called conspiracy theories. People wouldn't be trying to figure out why you're acting shady if you weren't acting shady. So it's a huge problem with this case. And it does, I agree. It makes it look like they were never looking for the killer. That's it for tonight, guys. It's another late night, but not super late. It is still early enough I can get a little bit of sleep. And as soon as you guys stop sending me super chats, OCD Shaggy, 111,000 subs. Congrats. Thank you so much. What was your sub count before the trial started? It was at about 87,000. And where do you think your sub count will be by the end of trial? I don't know. Like, I'm grateful for all the subscriptions and everybody who has gotten value out of the channel and is following it, but I'm really not like focused on it. It's not why I do what I do. I honestly picked up this YouTube channel as kind of a hobby because I was watching trials and talking about them anyway. And so people were encouraging me to do it. I did it. People seemed to like what I was doing. So I've kept doing it. And, maybe someday it won't be fun and I won't do it anymore. I don't know. I don't know what it'll be. I mean, it's great if it's more. It really is, not because like I'm out here trying to get more subs, but just because it's a reflection of the value add. And that's really all I've ever wanted to do. I've just wanted to be a value add in this process, to be able to provide something that people think is worth watching. So the fact that so many people think that, it really is very encouraging, and I appreciate it. And so with that, I am going to sign off now and go to sleep. Thank you all so much for your support. It's been wonderful. Really has. I think we are in the home stretch now, getting close to the end of the road, but it is very hard to say. So hopefully, all this chaos that has started to emerge with the line sitting and so forth will be managed, and we'll be able to get through the last little bit here. Because I really do want to make sure I've every day but day 5, couldn't be here for day 5, but every other day that I'm able to bring you the full and complete picture as much as I can of what's going on in this courtroom in this trial. Since we don't have the cameras to do it for us, well, might as well be me. So thank you all so much for joining me. Thank you, mods. Thank you, line sitters, everybody that's contributed to this. I keep saying this is a group effort. I could not be doing this by myself. I really owe a lot to all of you. And so thank you so much for supporting me and for helping me bring you this information about this case and this just terrible injustice that we're seeing unfolding. So with that, I'm going to look forward to a good night's sleep, and I will see you guys after day 19 tomorrow. Have a good night, everybody.